Yeah, please. Okay, may I mention item number 17 and 18, madam? A talk of amicable settlement is going on between the parties. 3 weeks time this is likely. Petition. Fine.
Lordship, HPCL. HPCL.
3 weeks. And another thing, may I pay for listing of a late petition for admission, madam?
May I please, Your Lordship, with the consent of other side, I beg to mention item 6. Jump for the day. Mr. Ken Chaudhary, senior advocate, is out of station, so. Item 6.
Elementary different finance.
Two weeks. Oblige. Two.
Please lodging. Mention letter for withdrawal lodge for tomorrow. No, please your lordship. Lordship, I beg to mention a petition for listing. Lordship may kindly be listed on Monday. No, newly filed. Wait, please, your lordship. Consent on the other side, expect to mention admission of 7. And the senior counsel is out of station. So she will put it on. She will.
I'm here for the respondent number 1. Would you kindly, if this so, kindly make it in second wait of 2. I'm attorney on behalf of Peanut. Sahani. R. Sahani. Alra. Peanut.
May I please, your lordship, with consent on the other side, lordship, I beg to mention item 31 to budget. Mr. Ken Chaudhary is out of station, your lordship. Senior counsel, Mr. Ken Chaudhary is out of station.
Not yet. Respondent number 1.
Yes, Doctor.
Next week, your lordship. May I wait for the 6th day, your lordship? Next week, everything.
But I am not complete. Yes, I'm led by senior advocate Ken Chaudhary, actually, the author of station. Next week.
My lord, may I please proceed as per last order, my lord. I have already filed an additional affidavit, my lord, for bringing on record my contract as well as the extension of my validity, my lord. I think that affidavit is not in record, my lord. For my lord, I provided an copy, my lord. My lord, this is the agreement, my lord, 75, page 75, my lord, of my additional affidavit. This is the agreement, my lord. Page 75. between my lord, additional chief engineer PWD, RNB, Hills, Assam and Tipur, and Bhaskar Sharma, petitioner. Then my lord, extension is at pace 93 my lord. My lord, last part, paragraph 3 my lord. Married my lord. After the threadbare discussion, the committee has decided to extend the agreement period till April 2026, and additional period shall be renewed every 1 year with the agency for the execution and extraction of PWD stone quarry at Pranpuri, Anglong, PP Lane, Stone, NGV on the demand of the development project, and also the committee instructed the executing the PWD Kohara Road division, if any review necessary on the present agreement to consult with Sri Bhaskar Sharma and submit to the additional. My lord. My lord, that is in my next, my read petition, my lord. My lord, page 26. So, my lord, LOI is also, my lord, valid till 26, my lord. My lord, page 67, my lord. My lord, serial number 3, my lord. PP Lane, Pranpuri, Anglong, Patta number so and so. Permit holder, execute.
Statement made by the petitioner, also been looking to my lord, page 10, paragraph 6. Paragraph 6, my lord. 1, 2, 3, 4, 5, 6 line, my lord. The incorrect statement, my lord. My lord, I read it. Thereafter, environment clearance was issued in favor of the petitioner. No environment clearance was issued in favor of the petitioner. Environment clearance was issued in the name of the executive engineer, my lord, and he has not been made a party in this petition, my lord. And the agreement was signed between the additional chief engineer. He was also not made a party in the petition, my lord. Without making them party, my lord, whether repetition lordship issue of notice at this stage, my lord, without making them a party, my lord. That is the first point, my lord. And the cancellation, my lord, permit holder is the, my lord, executive engineer, PWD Road Division, my lord. And he has no right whether that permit was cancelled, my lord. If he has any right on the executive engineer regarding his agreement for extraction of the stone of that particular quarry. And mining permit was issued in accordance with the, my lord, rule framed by the, my lord, by the government of Assam, my lord, Assam Minor Mineral Concession Rule 2012. Not paid a party, my lord.
My lord, that's true. My lord, my lord, that, my lord, my only prayer here. I am, my lord, doing my job, my lord, on behalf, yes, ma'am, that is correct, my lord. My lord, my only question here is, this cancellation, my lord, on the basis of, my lord, kindly see, for due to pending CTO, CTE, earnest money deposit, security money deposit, and non-clear keys money. My lord, that's why I'm coming for this court, because against PWD, I don't have any grievances, because, my lord, agreement is valid.
Permit holder, my lord, in that particular case, name of the permit holder, executive engineer.
Yes, my lord, already I have submitted in my petition, my lord.
But he has not been made a party, my lord.
Then, my lord, I may be allowed to, my lord, impede this, my lord, PWD, my lord. Yes, my lord, I may be allowed to withdraw it with liberty to file a case. My lord, here, only, my lord, my grievances against the, my lord, this department and my lord, my lord. Yes. No, my lord, I may be allowed to withdraw it with liberty, my lord. Yes, Singha.
mining permit for that. Yes, sir.
Not paying like. Yeah, please. This case was, person was paying for release of its capital liability, so boxes to us. I allocate.
ST box, Corporation Department. Respondent 1, 3, and 4.
Who may be registered?
Obliged.
Publish. Method regarding non-payment of contract. Each of the. My lord.
All the respondents. No, Lordship, except respondents 6 and 7. 1 to 5.
It's 798. Hello. The pendency cannot be planned. You go similar them. Similar play method. That's the same. Well, 7, 8, 9.
1 to 6. Obliged.
Planning Council, MSP, it has informed us another board, so it can be taken up after some time. This no, I don't know. He does. He does. After some time. Yes, I. Much.
May I please, Lordship? Lordship, we have filed the affidavit in opposition in 2019, September 9. Lordship, thereafter, there are very much subsequent development is there, Lordship. That's why I may be allowed at least 1 week time to file an additional affidavit in opposition. There are so many communication made between the parties, Lordship, but no, Lordship. Quite impossible, Lordship. Their development is there. It was filed in 2019. Lordship. Lordship. It is approved with. Lordship. That with regard to the statement made in para 9, it is stated that the petitioner completed the works and same were inspect and found functioning satisfactorily by the executive engineer PAC department. I am not PAC, I am Assam State Person.
Karimganj Division, Karimganj and AEPAC, Patharkandi Subdivision as per the status code. And para 7 lordship. Para 7 lordship. That with regard to the statement made in para 10, it is stated that the one running bill of rupees 1 crore 37 lakhs 85,588 lots. Total billing amount was lordship.
No, this also involves the MSME Acts. So let them file an affidavit. Say what is what. No, this is happening in 1919. In 19, they wanted to file the present petition.
Lords.
Because the amount which they paid in between and no, lordship, they have not taken the MSME into calculation. Being down is the MSME. No, lordship, it is not for premises because the amount is not disputed. We go to. No, council, I will go only this. Only we want them to implement the MSME Act. Lordship, I go to the council under section 18, only if there's a dispute in the amount. There's no dispute in the amount.
Para 7 lordship. I was reading lordship. That we regard the statement para 10, it is stated that the one running bill 1 crore 37 lakhs 85,588. Lordship, interesting matter, lordship, total billing amount was 1 crore 37 lakhs 85,699. Out of that, lordship, 1 crore 37 lakhs 85,588 already been paid, lordship.
That's
Billing amount was, lordship, total what tender value was 1 crore 37 lakhs 85,699.
lordship.
Out of that, lordship, 1 crore 37 lakhs 85,588 was paid as a first running bill, lordship.
Paid to housing board. Paid to housing board, but housing board for reasons best known, they paid only 1 crore 5 lakhs to us.
That after standard deduction,
No,
that amount has been already paid, lordship.
it's not, that is not the standard deduction. That is what the.
Oh, there are work order.
Yes, but the housing
is-
board is not paying that. You're for the
No.
housing board.
Assam State Housing Board, we are the executing and supervising authority. We are not paying authority, lordship. We are PIC, lordship. This is paid by the PIC department through us, lordship. Lordship. We have disbursed this amount. Lordship. Lordship. Lordship.
According to me, it's 32 lakhs. Yes,
Lordship. 13 lakhs 78,588, lordship. 78,588.
how they have made the same deduction, they didn't mention.
1,588 lordship. This is the remaining amount. And out of this remaining amount, say 8 lakhs already been is ready in our office. Sequently, we have invited them, but they did not come to for lords. It is ready in our office, lord. So what amount is released from the government of Assam? That was we are disbursing the lordship.
No,
Ready, lordship. Still ready, sequential. Several times we have invited them. Since 2000, lordship, there are later, lordship. That's why I'm paying that. I would like to submit it.
lordship, that is. No, admitted amount is there, lordship. When
It is clear, lordship. Out of
no, lordship, the MSCB auction is being denied.
MSCB, lordship.
MSCB are council here, lordship. The council, it's not applicable in the council, is section 18, this dispute. We are not even calculating the amount which is right, we are entitled to see. Let the calculation be done. Okay, I'll do the calculation and give it to them. If they dispute, we'll go to the council. So Lakshmi will give me some time. Lordship, I will do the calculation. Lordship will give me 3 weeks time. I will do the calculation. No, Lordship, because if it's not disputed, the council will send us back. No, we have not received the research letters, then get. Let them give us a file. No, Lordship, what was the delay in payment? They have to pay within 45 days. Lordship, let it come out after 3 weeks. I will take my insurance. Let it come out. No, Lordship, come out. Lordship, let it come out for 3 weeks. I will go, yes.
Lords. Lordship. Lords. To the petitioner. Lordship, it was a running bill we have submitted, Lordship. But Government of Assam has had released 1 crore 27 lakhs 7,000. That's why remaining 13,78,580.
They have
Lordship,
released 1 lakh, 1 crore 5 lakhs.
Lordship, Lordship, we have prepared as a running bill 1 crore 37 lakhs 85,518. And out of that, Government of Assam had released 1 crore 24,007. 24 lakhs 7,000. Lordship, this is already been disbursed. Lordship.
Ready to report, that's it, man. That's all.
Lords. Lords. To the
No,
petitioner.
the petitioner was released 1 crore 5 lakhs.
After standard deduction, it is, there are SD money is deducted. Lords. Lords. Feel to them.
Obliged, Mr. Lordship, may I peruse the last order, madam? Happy Rosh. My name is SP Dust. For that's number 3 and 6.
So the probably by now, biological inferences, the order of suspension of the registration. And if being a contractor, he won't be sitting till today, yes.
Yeah, my lord, whatever, my lord. Yeah, my lord, well, we have changed this watching of this affair, my lord. It reflects, my lord, your lordship, can you have a look? It seems that, my lord, it has been withdrawn. Lordship, can you have a look, please? Yellow page mark. Yes, my lord, page 35. Yellow, my lord, lordship will see the next. No, my lord, yellow mark after 2-3 pages. My lord. I have given my office book. Yes, yes. My lord, I have placed, my lord, while watching of the proceeding, my lord, that order has been. Yes, yes, same person. Impin order is of 4th September, my lord. On 10th September, it has been subsequently withdrawn. Because we challenged the FIR, man. My lord. But it may be given, my lord, as an one cause of action. And that judgment matter be kept as a part of the record. First.
Your lordship, this matter is taken up at so to as my council is wearing attending a matter at court. This one matter at court. At two.
This is permitted in our motion. In fact, I had approached the court earlier also. There was an option. If your lordship will come to page 52 of the petition. Page 52. And the relevant portion of page 53. In view of the above, the petition is discussed. Yes, thereafter they verified, they admitted it, and that is the lordship will find at page 60. Page 16. I'm entitled to 16,30,625. Then they did not pay. I filed the contempt petition. The contempt petition order lordship will find at page 61. And in page 62, lordship 6 months time was granted and it was closed. But then they did not pay lordship. Again, I had to before this one. By way of the present petition. So my humble request before your lordship is that it's been more than 10 years now. Work was executed sometime in 2005. Admitted about lordship, they should pay the earliest lordship. Since there is a delay lordship, I'm also taking interest on the principal lordship.
But our case, council case is that Karbi Anglong Autonomous Council, as part of verbal order of the district commission, deputy commissioner, my lord, work was executed by the PWD department, my lord. And the deputy commissioner wrote to my lord government that funds should be paid directly to the deputy commissioner, not to the Karbi Anglong Autonomous Council. So the Karbi Anglong Autonomous Council is not at all, my lord, liable to make the payment. District commissioner, Karbi Anglong, he issued a verbal order, my lord, to execute the work, my lord. Accordingly, work was executed by the PW department. Well, my lord, no, my lord, that point is there, my lord. So GAD, who will make the payment? GAD will make the payment, or my lord, deputy commissioner directly would make the payment. That point, my lord. So GAD, my lord. So, my lord, the government, my lord, lordship issue direction to the government, my lord. My lord, verbal work order by the district commissioner. So that is the point, my lord, at that time. Subsequently, my lord, they have annexed the document that the district commissioner wrote, the deputy commissioner wrote to the government to pay the amount directly to the district commissioner to disperse it to the petitioner, not through the Karbi Anglong Autonomous Council.
Lordship, we come to page 61. And Lordship, we come to 11 part of page 62, paragraph 6. Having heard the letter of counsel for the petitioner and the counsel for the respondents, I am inclined to dispose of this contact petition by extending the period fixed with the order date 1/4/2020 policy. Lordship. But Lordship, it was Lordship in the if your Lordship will come to page 52 for a month, Lordship will see the area of parties. It's a PWD and a deputy commissioner.
Page 23, my lord, the repetition, my lord. Lordship will look into that, my lord. Second paragraph. It may be stated that whenever the fund is released, the fund should be released directly to Deputy Commissioner Karbi Anglong Depot and should not be released to the Karbi Anglong Autonomous Council. That is our case. No, my lord. Fund, DC may say.
This fund has to be released from the PW department or government. From the PWD, Commissioner and Secretary. Because Lordship, PWD has filed affidavit. That's one number 5, Lordship, that we have, the Deputy Commissioner had wrote to the PWD officer. They have stated in their affidavit, Lordship. And they are saying, Lordship. Page 3 of the affidavit, Lordship. Filed on behalf of respondent number 5, Lordship.
Lordship will see paragraph 4. Of that.
Of
Filed by the
respondent
respondent
number 5, Lordship.
That is the executive.
In the PWD.
Paragraph 4, it starts from page 2 below. And in page 3, I'll just read from page 2. That works of improvement of infrastructure of designated field at Diffu, Bokazan and 100 of Karbi Anglong district for observing Independence Day Republic Day function. An estimate of 75,90,600 was prepared by the respondent 5 as desired by the Deputy Commissioner. Karbi Anglong Diffu and communicated by the number so dated 1/7/2005. The cost of improvement of infrastructure of designated field at Diffu was 22,86,547 For Bokazan, 26,47,971. And for Amre, 13,38,692. The work for improvement of infrastructure of designated field at Difu and Bokazan was executed by the petitioner, and he has completed only part of the work. No formal work order was issued to the petitioner. The executive engineer PWD Difu Building Division wrote to the deputy commissioner Kabiya to issue the work order. The approximate value of the work done by the petitioner are 5,30,682 for Difu Stadium and rupees 1082,949 for Bokazan Stadium. The deponent has already communicated about the work done by the petitioner to respondent number 3 on 25/7/2014. But the deponent has not yet received any administrative approval for the work executed by the petitioner. Now, Lordship, that the work has been executed to some extent, has been admitted by them, and what amount of work that is quantified by them. And it is only that admitted part which I have seen. Now, for interdepartmental motion conflicts, I cannot make to suffer motion. Since Lordship, the work was given by the deputy commissioner and the estimate was prepared by the PW. Secretary GAD is not a party here. It's a party, Lordship. Party number one. Party number one.
Provide the fund. So it has been executed. No, PWD, but PWD is the executing authority. Well. Yes, my lord. In that case, my lord, can you give my lord 1 week's time is given, I will clarify my lord from the CAD and the PWD itself, who will be the authority will provide the fund.
The same submission provided on the earlier occasion also, Lordship. The same submission. All right, Lordship, we give one step. Yes,
My lord.
Lordship. Lordship. Yes. Yes.
I will appear.
Yes, yes. Improvement of infrastructure.
Five and six, five.
Motion, page 16, motion. Plan, sure, sure, plan. Another fine question. In Bokazat and that's reflected in page Bokazat and before. Paragraph 2.
Part of the work.
2 weeks when it goes. But one of the petition is a successful video. And
Lordship, we have sent an affidavit of vetting, Your Lordship. We'll get it by next week, Your Lordship.
6 years, man.
So, Your Lordship, just. Just a week, Your Lordship.
At the
Otherwise,
very initial period, there was an interim order, so that your lordship will take care of that. There was an interim order. That was not for a specific period of time. First order. Yes, ma'am, yes. Madam. Ma'am.
just a week, Your Lordship. First. A week, Your Lordship. Omelette.
Pilot, small improvement of pilot contractor bill. And India affidavit, they have affidavit, your lordship can pilot my para 2 of my petition, para 4 of my petition. Para 4 of the petition, madam. Total outstanding bill 50 lakhs 11,724. Page my lord, your lordship go to page my lord 3, page 3 last para 4. Yes, madam. So I have given a short my lord. That is my total amount is now my lord in their affidavit. In the meantime, some amount has been paid. Now they admitted my lord. Dear your lordship kindly see their affidavit. 50 lakhs 11,724. Admission that para 5 of the their affidavit by lord page 54 by lord page 54 by lord planning page 54. Page 54 by lord. Page 54 para 5.
45 lakhs.
Yes, now at present now 35 they admitted that 35 and for para 6 your lordship kindly para 6 now. That we take out the statement made in paragraph 5 of the fifth petition, the different to state that an amount of 35,771,700 only is payable to the petitioner. So that they admitted. So they have already moved for fund my lord. So that is admitted. Because after my lord filing this matter, some has been paid my lord. Now this is named.
35 lakhs.
Now my lord, it is outstanding 35 lakhs 71,000.
Lordship, may dispose of, I have instruction that they will be paying the amount shortly, Your Lordship. Lordship, may dispose of the direction to respondent number. I am paying for respondent number 2 and 5, Lordship. So the direction we issued respondent 2 and 4, the 4 is the district election officer. So the amount should be paid as 2 and 5 I am paying, and my friend is paying for 4. Lordship. The chief electoral officer, he will be doing the direction we issued to 2. 4, Lordship. So to both, yes, Lordship.
Thanks a lot.
A Borua. AIL. and 5.
Four, Lordship.
Simple standing of the.
I had to go PS for 3, Lordship. No, Lordship.
My lord.
On time, Lordship. 3 months.
Asking for adjustment, your lordship, for this mentor. No, he's not asking for a payback. He's asking that since I refund and adjust for his existing wholesale layers. That's what it is. But the rule doesn't say whether it can be adjusted or refunded, your lordship. Please silent about that. We cannot pocket it, but lordship, but he hasn't made a representation. But make a representation that upon the commissioner decide. He has always made a representation. Lordship. We will take a conference. When के feed warehouse. He has applied for this bonded warehouse license and wholesale license. We have given a wholesale license. Check the point also because it's already submitted three representation and there is an order at page 24. Because at page 24, the page 24 also, annex A. Yes. In persons of government approval, conveyed guidelines so and so. Necessary revised sanction of the establishment bonded warehouse, license of IMFL at Pamoy Moza Ramcharan, so and so. At the rented premises, so and so, covered by taxation under Ramcharan, so and so, is hereby acquired for year 16 as per provision good for Assam bonded warehouse. However, in the event of change in revenue patterns, increase in license fees, etc., the licensee will have to pay the differential amount without which the license deemed to cancel automatically or also. He has to pay, he has to pay the differential amount, your lordship. The bonded license fee was so and so to be adjusted for the year 2016 and 17. For 16 and 17, we have adjusted. No, we have not filed it. Second thing is that it is gone and its representation is at page 27, your lordship. 27 and 27 also. And extra 11. Very well. Lord. All right.
On the last date, instructions shall be provided regarding the pending amount of 24 lakhs, that is the aggregate amount stated by the. Takes up the last quarter 21 to 20.
My lord, thereafter, my lord, 1,50,000, my lord, paid, my lord. So the remaining lordship will dispose of you with a direction to, my lord, admitted to verify and admit, pay the admitted mortgage.
Again, for them.
Within 4 months, my lord. within 4 months, my lord. My lord, second budget will come in the October, my lord, so I'm saying. Budgetary provisions, my lord, twice, my lord. The budget provision is coming twice in a year, my lord. My lord. My lord. Lord, I have not. My lord. Very few cases is pending, my lord. My lord, very few cases is pending. My lord, very few cases is pending here, my lord. Very few cases, not 10 also. In as per cardiology. Madam. Madam. So 4 months, madam.
Lordship, the last year, 3/9/2024, Lordship, there is a extraordinary. They have stated that they will pay within the month of December 2024. And that was of September order, Lordship. And by January, the matter was listed, but that has not been paid, Lordship. They have stated they will pay within 4 weeks.
Is it within 4 months you have paid to pay the merchant? My lord, my lord. My lord. My lord. My lord.
September,
My lord.
Lordship. 4 months time.
My lord. My lord, subsequently they have paid in 2024, 1,04,440. My lord, then my lord, in 2025 paid 50,000, my lord. So they have paid 1 lakh. My lord. Lordship, lordship, I should have. Within 4 months, fine.
The matter pending, otherwise nothing will happen again.
Now, we have paid in 6/12/2024, 1,04,440. My lord, then thereafter 50,000 paid in the, my lord, February 2025. 50,000. My lord. My lord, next budget will come in October, my lord, so I'm paying for that. My lord, so may pass an order if you are not paying before, within October, my lord. My lord. Lord, so may observe it, my lord, if fail to pay the, make the payment, my lord, within October, my lord. My lord, then necessary, for personal appearance of the secretary. Or like that. Will appear and explain, my lord, why he did not make the payment. No, he will explain, my lord, personally, my lord. He will explain why he did not make the, obey the order of the bill. That Lord, grant me some 10 days time, we'll file the affidavit to that extent, my lord. My lord. My lord. My lord. My lord, execute me for the budget, my lord. My lord. My lord. My lord. Lord. Lord, you pass the appropriate order. My lord. My lord. Lord, you pass the appropriate order. No, now my lord, PWA department is running by the deputy secretary. Deputy secretary. Is there. Lordship, day after tomorrow, my lord, I'll take the instruction. And definitely instruction in writing, my lord, that they will make the payment. Or if you will appear, my lord. Monday. Monday. Thereafter, 1,54,440. For then again 50,000. That is sanction on 6/12/2024 sanction. Another amount of rupees 50,000 on 19/02/2025.
20. Okay, now it's okay. Full stop. Mr. J. Tutesh submits that he will obtain written instructions by Monday as to the amount payable to the petitioner and the date by which the said amount would be paid. This is the matter, Raman.
Lordship, in this matter, I have received instruction, our affidavit is ready for swearing, Lordship.
Huh?
Our affidavit is ready for swearing on behalf of respondent number 3.
Okay, so it's prepared. So it has to be, when will you file?
Lordship, 10 days.
Why? Where is, who is the deponent? If it is ready, what?
Already we have sent for vetting, Lordship.
You said it is ready for signature. There's a difference between vetting and signature. Which one are you, which one is your submission?
Yes, Lordship, sent for vetting, Lordship.
Vetting. Okay, it's all right. Mr. S.R. Barwa submits that the affidavit to be filed has been sent for vetting. Where is, let me see your affidavit which is to be sent for, which has been sent for vetting. It is this vetting or for swearing?
So Lordship, what we normally did, we provide them the soft copy.
Whatever. He submits that the affidavit will be filed within 10 days. Huh? Vetting and the same will be filed within 10 days. This is the matter. After 2 weeks.
I will do one time to the garden, so I might reply affidavit. They want it.
Malad, we have filed affidavit.
So you are challenging the award of the contract to the point number 5. So Mr. M.J. Kadir, learner counsel for the petitioner, is granted how much time? Granted a week's time to file affidavit in reply. This is the matter of Miss D. Jane. Miss Jane. Have you told her? No. See, those matters we had picked for 2nd June.
Second,
We're shifting it to 10th. Is it okay? 10th June.
10.
Matter I have received some instruction, but this is not complete of it, so I need some more.
Okay, Mr.
C. Sharma.
C. Sharma, learned standing counsel, and he submits that though he has received instructions, the same are not complete. He is accordingly granted
3 weeks then.
3 weeks time to obtain the required instructions and file affidavit. This is the matter of the 3. This is the matter of the 3.
Published.
Yes, who's appearing? Irrigation department. Last two of them, they take time, but they.
Huh?
Last two of them, they take time, but they have not filed affidavit. So, affidavit amount
N Upadhyay,
is 19.
page 19.
Affidavit amount. Bill number 3, Messrs. Unique Enterprise. Balance table is 2,950. Okay, petition has minor side, height, so. Yeah, this is there. This 20th is the.
The council is not here, what to do?
After something.
Call it.
Not we served a copy of the affidavit in the possession yesterday,
Yeah.
but there's a small issue that I'd like to point out, my lord. If my lord can kindly come to the impugned order, my lord, at page 79.
Yes.
This is the environmental clearance order, my lord, which we challenged. The rejection of our claim for 2 years was rejected, my lord. The reason's been given at page 80. Page 80. The paragraph in bold, my lord. The extension of the environmental clearance for a period of 2 years up to 30/10/2025, not covered by the approved mining plan, valid up to 14/5/2025. Today we are on 21st of May 2025. So what happens is that there is a longer tenure of agreement of the forest of 7 years. The environmental clearance was initially given for 5 years, which was extended for only 6 months, pursuant to which I approached this honorable court. Your lordship have given the petitioners a direction and liberty to approach the authorities and for them to dispose of our petition. Now, the new ground which is taken by them, which has been assailed in this petition, my lord, is that now they have taken the fact that the approved mining plan expires on 14/5/2025. So the entire tenure of my agreement is 30/10/2025. They cannot give a clearance for. That is the ground that they have taken. Now, we have
So
filed
where is your approved, new approved mining plan?
my approved mining plan is 14/5/2025. What
And the
happened?
new plan, no new plan has been made.
No. So what happens, my lord? As I understand, subject to correction from my friends in the forest department. Initially, an approved mining plan is given for 7 years. Thereafter, the environmental clearance is given. And then, my lord, the settlement agreement of the mining area is done. So there's a sequence that follows. Now, the approved mining plan was from 14/5/2017, 2018 till 14/5/2025, 7 years. Based on that, the environmental clearance was given for 5 years. Now, based on the approved mining plan and the environmental clearance, I was given a longer tenure of 7 years, which expires on 30/10/2025. Now, my lord, in paragraph number 9 and 17 of the writ petition, we have highlighted similar instances where the approved mining plan expires at an earlier point in time, but the environmental clearance has been given for the entirety of the settlement agreement. Now, the reasons that they've taken earlier, before the first order of application before the honorable court, and the reason that they've taken in this round of application are completely different. Reasons that they take. And not just,
So earlier the issue was that not enough sand,
not too meager. They're too meager.
too meager,
The
not
word
enough
was
sand.
just 2 meters. The reason being, my lord, what happens is there was a 7,000 cubic meters of sand that needed to be mined and 7,500 cubic meters of stone to be mined. Now, the pattern and the quantities that had to be mined annually if that rate was followed, that would have left us with that meager amount. Because we could not have mined more than 1,000 cubic meters, that we what we did. So resultantly 2,000 cubic meters were left for the next 2 years. That is your interpretation. No, that is mathematical interpretation. That is not my interpretation. In fact, on the same amount of sand and soil to be mined by the cases that you have referred to in paragraph number 9 and 70, they have allowed the environmental clearance for the entirety of the settlement period. Now, my lord, if your lordship takes up, I am not sure if
What do you want?
I want is that, my lord, the environmental clearance should be given to me till 30/10/2025. The lordship had granted me a stay, and that is my only prayer, my lord. I'm seeking my prayer based on parity with similarly situated contractors, because that is the sequence that happens. These are boilerplate numbers, my lord. These are not numbers that will be fixed subjective.
So, but once you get the environmental clearance,
Yes,
then you'll have to again make a mining plan.
the mining plan stays there.
Because that mining plan approval is only till 14/5.
14/5. Now, the
That
reason
can
why-
be extended.
No, that has to be extended because that has to be coterminous with the term of the agreement. Because although the approved mining plan was approved on 13 or 14.
The settlement was made
2025,
subsequent.
I started working only from 1/11/2018. 11/2018. That is at page 49. That is when I finally entered into the agreement with the forest department. So there's a sequence that happens 7 years, 5 years, 7 years. That is my claim, my lord. And the fact is, the agreement stands. The clearance is not given. Based on similar situation, somebody else was also given similarly situated individual is similar quantity, my lord, and not different quantities. Now, what they have done, the environmental authorities, what they have done is they have predetermined the contract. They've predetermined. They've determined the failure of the contract. They've rendered it entirely fruitless. That is my submission, my lord. 9 and 17.
No,
they have
my
not-
only concern
Yes, my lord.
was that when they said that they are not, there's the sand is too meager. So what did it mean? That there was hardly any sand to take out any further.
And we have justified that by showing parity, my lord. I'll show you. I'll satisfy this. court.
That is the issue.
I'll satisfy this court, my lord. If your lordship can kindly come to page 30, page 20. That has been highlighted, my lord. Page 28, my lord. My lord, page 27. I apologize. Page 27. Page 27 is annexure B, my lord, where I was given the environment clearance.
Where?
12/10/2018. The lordship will kindly see the paragraph that follows the first paragraph, my lord. The quantity of collection of sand and stone is as follows. Sand, 1,000 cubic meter per year only. Stone, 2,500 cubic meter per year only. I could not have exceeded that limit. That limit, out of the entire limit which I had to mine, left me with the amount which they've stated was too meager. My lord,
Okay, so do you mean to say
yes, my lord.
now they have done away with the first reason, the earlier reason?
Yes, yes.
That meager part is no
Now,
longer.
now they have come to the.
It's only with regard to the
Yes.
mining plan.
Yes. And my lord, if your lordship can kindly come to the last page of the petition, last page. This is the similarly situated individuals case which we have also. Page 81, my lord. Page 81. Page 81.
Yes.
Your lordship, this is the declaration, this is the approved mining plan, which has not been disputed by the authorities. This is dated 7/9/2017. 7 years from here, my lords, would indicate 6/9/2025. Your lordship sees that. 24. 26/9/2024. This is when the approved mining plan ends. Now, my lord will kindly come to annexure I at page 59. Same individual, my lord, Mangsuna, page 59.
Yes.
Page 59 to the same individual, madam, Himanshu Nath. The environmental clearance now for the same amount, but I'm not harping on that aspect of the quantity to be mined. This is letter dated 14/2/2023.
The term is at page 62. Page 62,
Yes.
number 8. The environmental clearance is valid for another 2 years. That is till 29th of December 2024, whereas this approved mining plan ends in the month of.
But this letter is of 23.
Yes, because his approved environmental clearance has ended in 22. Because what happens is
During that time, the mining plan was still valid.
the mining plan was valid till the month of September
24.
24.
And this is of 23.
Yes, my lord. So,
Your case is,
yes,
now your mining plan now has,
now it's the mining plan.
now your mining
Yes.
plan is now expired.
Now mining plan has expired. Even my lord, if your lordship sees the date in which the environmental clearance is granted till 29th of December 2024. On 29th of December 2024.
You mean to say that they have given permission beyond
Yes,
the
yes,
the expiry date?
To be co-terminus with the term of the agreement. That is my case, my lord.
Yes.
Right, technicality, my lord. That technicality, that's how the process follows. The boilerplate numbers, my lord. These will not be indicating the environmental clearance.
Let us say
Yes,
that.
I'm, I filed my affidavit on behalf of respondent.
Who is respondent number 2?
The state environment impact assessment.
You are the one who is supposed to give the environmental clearance, correct? So why you not giving the clearance? Because of the fact that the mining plan has expired. You have validity of the mining plan has expired.
Kindly have a look at office memorandum dated 18/5/2020.
Page.
Page Milo 25.
Huh?
25 of the petition. Page
Yes.
Page Milo 11 page 29 Milo.
29.
This is the general condition.
29 is something.
29 my lord.
29 is
Nine,
part.
Annexa B, my lord. Annexa B, my lord.
Huh?
Annexa B.
29 is a letter written to Sujit Sarkar.
Yes, my lord. Annexa B.
The environmental clearance, my lord.
Ah,
The environmental clearance. For 5 years,
ah,
not the old.
yes,
20, page 29, my lord.
yes, 29, I've got it.
Clause 8, my lord.
Clause
Clause 8.
8,
General condition. General condition.
yes.
Clause 8. The environment clearance is valid for a period of 5 years from the date of issue of the order, extendable by another 2 years, subject to availability of materials.
Yes. So have you extended it for 2 years?
6 years, only subject to availability of material.
So where does it say that there is no material?
I have find my lord. Para 2, my
Para?
para 2 page.
Para?
Para 2 page 83 of my.
83.
Sapera 2, my lord.
Huh?
Sapera 2. Page 83.
Yes.
Rupan 2, my lord. That admittedly pursuant to the application.
Wait a minute. Para 83 affidavit on behalf saying completion of the service. 83.
It might not be in record, my lord, because it was filed yesterday.
Oh. Anyway, you give me a
No,
copy.
I can.
You filed it yesterday.
Not, I'm handed over to on 16/5, handed over to my.
It is not here. When did you file it?
Yesterday, my lord.
My lord, some difficult.
When did you file it?
I handed over on 16/5/2025.
You filed it on 16/5.
16/5. Handed over to my.
So it is
clerk.
not recorded here.
It is-
Anyway,
But because of some difficulty with
let us see. Yeah.
to my lord,
Huh?
to para 83, sub, para 2, to Roman 2, my lord.
Admittedly, pursuant to the application dated such and such, they are submitted to the respondent number 5. And the later dated such and such which require documents of the respondent number 5. And addressing to the chairman, here, SEIA Assam, the extension of issue was issued by the here Assam for a period of 6 months on the basis of recommendation of the state expert.
Council,
tribal
go to the issue, there's no point reading it.
My lord,
What is the reason for not giving him environmental clearance? Go straight away to that.
my lord, at para 4, my lord.
Para
Next,
4.
para 4.
Para 4. Yes,
Para 4, my lord, Roman 4, my lord, page 84.
page 80,
Page 84. Roman 4.
okay, sub
Same-
para
same-
4,
same para.
2, 2, 4. Yes,
The application for extension of EC was submitted by the petitioner on 27/5/2012. Extension of amendment plan was rejected by the chair, Assam, by dated 18/10/2020 on the following ground. The condition of the EC were as were required mandatorily to be fulfilled by the proponent were not complied with, leading to such irregularities lacking due vigilance in the mining area to avoid any kind of irregularity, illegalities during the mining period. B, my lord, essential documents of reply were furnished
Council,
partial.
one thing. Is this your prerogative?
Some read.
Is this something you are supposed to monitor?
Yes, my lord.
And then, if this is, so this is the, huh?
All this aspect, my lord.
We have got to monitor. Is it?
My lord, DFO concerned.
What is the role? Have they have got that there were irregularities lacking due diligence in the mining area?
They-
With not adhering to time and compliance. What is this?
My lord, DFO concerned DFO submitted the reports, my lord, status report.
You see, the environmental clearance has to look at what are the parameters before issuing environmental clearance. Number 1. Number 2, the reason given for rejection of his environmental clearance apparently was only the expiry of the validity period of the mining plan. Can you now give other reasons which are not there?
Well, other aspect also for granting environmental clearance, my lord, other aspect also consider. That next, my lord, C, my lord,
Yes.
then C, my lord. The DFO North Kamrup division has submitted by letter such and such that the mining area is lying idle since 2023. After the expiry of the issue and also after expiry of the extended term up to 2/7/2024, which indicates that the proponent has not availed the chance of extension of mineral even after granting our extension of the EC by another 6 months, which was at this date.
Tell me what is the parameters required to be considered prior to issuance of an environmental clearance?
Well, essential documents.
Have you got any office memorandum, any notification, any guidelines? Nothing.
My lord, I'll satisfy for my son of report, my lord. The next day, my.
No, today. Not, if you cannot satisfy today, you will not be able to satisfy the next day.
Because they are mandated, they are obeyed by the terms and condition of the agreement.
Let us see the reasons for rejection of his environmental
Reason
clearance.
is there, my lord, this is the.
No, not your affidavit. As per the communication given by you to him, where is that communication? At page 81, what is it?
79.
79.
79.
Explain the page 80.
79. The reason
The
is
page
given here. Not covered by approved mining plan, that's all. Can you go beyond this reason? by way of an affidavit? What does the Supreme Court say? Ms. Gyan, I have already spoken to Ms. K.K. Chowdhury and Ms. D. Jain that 2nd June matter, 10 June. 10 June. The affidavits are all ready, no? That is the only reason you have given him, communicated to him. You have not communicated any other reason. Yes, Mr.
At
Gogoi,
page 95 of my affidavit.
95. What
It
have
is
you
the,
said?
Letter to the chairman,
95.
the
95. 95.
regard
Yes,
95 of my affidavit.
yes.
Uh, Sir, with reference to the service certificate, I have the honor to forward here with the letter number substantial reference under reference along with the enclosure submitted by the Range Forest Official Bopeta regarding the extension of validity of environment clearance of the NKD B3 Dumuni that mining contact area. The mining contact area has been settled with Sri Himanshu Nath for 7 years and environment clearance issued only for 5 years for from your end with effect from such and such. The mining contact area has been settled up to a month. Now the mining contact area is running with 5 years 3/4 decrease. In this regard, I would like to detail quantity of mining sand and extract performed. This is in case of mining of Himanshu Nath mine, 7 years environmental clearance are issued only for 5 years for
Yes. Well, is there any complaint against the petitioner regarding the mining being done, undertaken by him? No. He has to give up? Okay.
If he cannot get
Once he gets the environmental clearance, then you will approve his mining plan.
Yes.
Or you will extend his.
That is sequential order of things. That's the timeline.
Okay, I think I've heard you.
minutes of the
Minute's not required. Your order rejecting his application is sufficient. Your reasons given here as per the Supreme Court judgment, then I think that it cannot be accepted. You cannot give reasons more over and above what has already been stipulated in the order rejecting his application. Yes, anything else? Anything? Right. Heard Mr. M. Sharma, learned counsel for the petition. Also heard Mr. A.K. Datta for respondent number
1 and 2, madam.
1 and 2. Also heard Mr. R. Gogoi for respondent number 5 and 6. The petitioner's case is that the petitioner has been settled with the NKDB dash page order dated 4/11/24. Take the first para, take the second para, take the third para.
then para 4, para 5 also. Para 6 also. Next slide. The petitioner's counsel submits that though the petitioner had been selected as the successful tenderer for the mining contract, the sequence of events that are required to be followed for extracting sand and stone is that environment clearance has to be obtained by the successful tenderer. Thereafter, the mining plan has to be approved by the forest department. And finally, the settlement agreement has to be made between the parties. The petitioner's counsel submits that the settlement agreement submits that the environmental clearance had been issued for a period of 5 years. By letter dated
12/10/2018, my lord.
12/10/18.
Page 29.
12/10/2018.
2018.
And the mining plan had been approved on
The mining plan has been approved on, my lord, it has to be 5 years. It
Had been
expired on
approved.
14/5/2025.
had been approved sometime in 14/5/2018.
2018. Yes.
Thereafter, the settlement agreement was executed on
29/10/2018,
29/10/2018,
effective from 1st of November
effective from 1/11/2018.
18.
As the settlement period was for a period of 7 years, the settlement period was to expire on 31/10/2025.
30/10, my lord, that's what's been given throughout.
30/10,
30/10, not 31/10.
30/10/25.
30/10 was the date specific.
30/10/2025. The extension applied for earlier. The extension of 2 years applied for earlier had been granted only to the extent of 6 months. And not for the remaining 2 years, as was required for the petitioner to have completed working during his settlement period. He submits that when environment clearance extension had been given for 2 years to another tenderer with regard to another mining area, contract mining area, that is Shri Himanshu Nath, there was no reason for the respondents number 1 and 2 not to give environmental clearance for the remaining 1.5 years, as the settlement period of the mining area had been made for 7 years. Next para. Mr. A.K. Datta, the learned counsel for the respondent number 1 and 2, submits that the prayer of the petitioner for extension of the environmental clearance had been rejected on the following grounds. A, B, C. No. Is it? Wait, it is no. It is ABC. 4 ABC. ABC, that's all, no?
Mr. Data, ABC, for ABC,
ABC and another mallet 5.
5. ABC and this doesn't support you at all. You want this? First up. ABC. He however submits that environmental clearance had been extended for Shri Himanshu Nath as for another 2 years beyond the initial 5 years. Why have you extended? Himanshu Nath?
More than area is bigger than the petitioner. Small and not.
Because the mining contract area of Himanshu Nath was bigger than the mining contract area of the petitioner. That's all. Okay, right. Mr. R.R. Gogol, the learned counsel for the Forest Department, submits that though the validity of the validity of the mining plan of the petitioner, which had been approved up to 14/5/2025, the same can be extended, provided the environmental clearance is extended by the respondents number 1 and 2 till 30/10/2025. Correct? In as much as his mining contract area is till 30/10/2025. Okay. It will continue twice. That's all I think. Next, I have heard the counsel for the parties. As can be seen from the impugned letter dated 18/10/2024, issued by the respondent number.
Respondent number 2, my lord.
Respondent number 2. The environmental clearance that had been given to the petitioner has not been extended only because the petitioner's approved mining plan was valid only up till 14/5/2025. The extract of the impugned letter dated 18/10/2024 rejecting the petitioner's application for extension of the environmental clearance is reproduced herein below as follows. Page 80 in blue. Okay. Next. The fact that the environmental clearance of Shri Himanshu Nath had been extended for another period of 2 years, beyond 5 years.
Beyond the approved mining plan, my lord.
Beyond the
Approved mining plan.
beyond the validity of the approved mining plan of Shri Himanshu Nath. Goes to show that there is no basis for rejection of the petitioner's application for extension of the environmental clearance beyond the validity period of the approved mining plan. To stop in any event, the counsel for the Forest Department has stated that the approved mining plan of the petitioner, which is valid up to 14/5/2025 would be extended till 30/10/2025 if the if extension of environmental clearance is given by the respondents number 1 and 2. Next paragraph. This court on considering the fact that the petitioner's settlement period of the mining contract area is till 30/10/2025. And keeping in view the fact that in a similar case of Shri Himanshu Nath, extension of the environmental clearance has been given beyond the validity period of the approved mining plan, there is no reason to reject the petitioner's application for extension of his environmental clearance. Next paragraph. The submission made by the council for the respondent number 1 and 2 that the contract mining area of Shri Himanshu Nath is bigger than the contract mining area of the petitioner, and hence an extension of the environmental clearance for Shri Himanshu Nath had been approved, is discriminatory and in violation of Article 14 of the Constitution. Next paragraph. With regard to the contention of the counsel for the respondent number 1 and 2, that the petitioner's application for extension of the environmental clearance on 3 other grounds that has been referred to in the foregoing paragraphs, besides the expiry of the validity period of the approved mining plan, which has been reflected in the affidavit in opposition filed on behalf of the respondent number 2. Cannot justify the rejection of the petitioner's application due to the fact that the respondent number 1 and 2 cannot go beyond the order, impugn order dated 18/10/2024. In this respect, it would be profitable to refer to the judgment of the Supreme Court in the case of so-and-so versus so-and-so, wherein it has been held. Take next. On considering all the above reasons, this court finds that the respondents have arbitrarily denied the petitioner extension of his environmental clearance. Consequently, the impugned order dated 18/10/2024 is hereby set aside. The respondents number 1 and 2 are directed to immediately issue and extension of the petitioner's environmental clearance till 30/10/2024.
There I have a submission to make. The subject to, because these are two independent documents.
Now you're going to say since you have lost out on 1 or 2 years.
1 year. Now the ball is in their court. The forest department's court will follow.
Then for that you can go and maybe ask for adjustment of the
That can only happen if the mining plan, the environmental clearance extends the period. Only for then they can extend the period of the mining agreement. Extends it expires on 30/10. The environmental clearance I'm seeking for the remainder of the 1.5 years. Now, the moment that happens, it's only then that the forest department can act on the discretion and decide to grant me if at all they do. Now, if the environmental clearance expires on 30/10 with the agreement, the forest department will have no hand to play with it.
What?
The forest department can only extend the mining agreement if I have an environmental clearance to back that up.
No, it's only till 3010.
No, the environmental clearance is not. to
Now you're going to extend now you're going to ask for extension of the mining area. Huh?
Wants to
If I want, yes, yes.
we have to submit application 15 months prior before the expiry of the mining permit. One extension of that. And submit, you will submit the application regarding extension of mining contract.
I could not have, but I have a very different time. The fact is, the forest department is over the mining agreement that extends on 30/10/2025. There is no dispute to that. The environment clearance from 3/1/2023 4 ought to have coincided with the entire WP agreement, which for some reason it did not. The environment clearance, which was initially given to me for 6 months, expires in the month of July. This is the month of May.
No, because now this is going to spill over.
No, if it spills over, the ball is in the court of the forest department to grant me that right or not, it is subject to their discretion. There I
You're going
follow
to come to this court again. You're going to say that this court has given this order for extension. So I should be given time period to work for the period I was not allowed to work.
I have been to do this to an extent, my lord.
So you can make a claim for adjustment of your installment money or KISS money or whatever. Yeah, but I will, you cannot be allowed to spill over the area.
It can only spill over the agreement the forest department extends. The environment clearance alone on its own weight cannot grant me the right to mine. The mining right has to be given from the forest department. That is a discussion that they have. Your lordship will observe that. At least I can follow that up without approaching the doors of this court at the first instance, my lord.
He wants to work beyond 3010.
No, the reason being, no, because I was not allowed to work within the confines of the agreement.
That was what I was slightly scared of also in the beginning, that you would work.
That is my submission that I'm not following it up with the authorities now. I'm only following it up, responding to 1 and 2 that grant me the right to the environment clearance for 1.5 years.
You were asking for a foot.
No, my lord. I'm not asking for something which cannot be given to me. The environment clearance can be given to independent of the forest department, the agreement of the forest department. It is then for the forest department, then this court will have no handle in saying that the agreement has to be extended. It's a completely different claim altogether.
We are going to say now that you should be given environmental clearance for 1.5 years.
For the remainder of the period.
And then accordingly, you will ask for another 1.5 years of mining.
And they can refuse, and that is a subject matter, a fresh cause of action. That is a fresh cause of action.
Okay, just say, don't say till, just say issues environmental clearance. That's all. Don't say till. Don't say till, that they don't put that.
I subject to the lordship's arrangement that will create more problems, my lord.
I've already made it clear in the beginning that you had asked for another 1.5 years. Or 2
Then
years.
your lordship will can be restricted to the 30.
Huh?
Your lordship will restrict it to 30 then.
Why?
If the environment clearance. If your lordship does not give a date, then the authorities might respond number 1 and 2. They might even not understand the purpose of the order. Your lordship will kindly give a fixed timeline for the environment clearance. Still 30/10, my lord, I'll be satisfied.
I will see. Let me see. The rate petitions accordingly, this program.
Grateful. 25.
Put that, we did that. Item 35. 25. Oh.
Lordship, this is regarding non-payment of contractual dues to us. So say, I need some more time. 1 week loss.
Okay, Mr. N. Upadhyay, granted, how much?
1 week loss.
Are you sure?
No, I have received by.
Huh? You have received?
Some instruction I received.
Oh,
They
it
admitted
is
amount.
granted a week's time to file affidavit in opposition in as much as he submits that he has received some instructions with regard to the claim of the petitioner. This is a matter after review. Then others cases also come. You see, we are having cases after 5 years and all. When did you finish your contract work? Which year? 2015. When did you file a writ petition?
24.
Huh?
Last part of
24.
Last part of
24. So you waited 9 years. You wait for a few more months, a week.
Lordship, on behalf of the district commissioner, I have filed affidavit that from the Department of Geology and Mining, instruction is awaited. Lordship, I need some further time to file our affidavit.
Item
27.
seized.
But the only problem is the police is since a year. And
Huh?
the coal that has been seized has been flying since a year now. And the material will deteriorate. So it won't be of any use to anyone. A lot. So considering those aspects, a big file in the time frame and put to disposed of. Or else, my lord, I was proposing if they could take an indemnity bond and release my coal, my lord. That would also serve the purpose.
How much is the cost of the coal?
Why not that subject that keeps on changing?
You've got
I
like
have the-
approximate
I have the
cost
Quantity, my lord, I know the.
so that you can at least deposit some amount.
My lord, then let me make a prayer to them for submitting.
You can, you see, in the, otherwise, if it's subject to decay, they can make an application or they can make an application to you stating the approximate cost of the coal.
Well.
They can deposit that amount and then send it off. There's no use if it's all goes bad. Supposing he wins the case, he'll be left with zero.
Also, let it come on the next day, lordship. I will also obtain instruction with the figure.
He has not filed any application for selling. Any interim order pass.
Yes, my lord.
Any interim order,
With regard to the e-auction.
stay the in auction.
Yes, my lord.
So let it be sold. What is there if it's going to be done? How?
But the amount that they receive after selling my coal, that has to be given to me or kept in.
Correct, it will be kept. So we can,
My lord, there is also small dispute with regard to the quantity, my lord. When they came to my place and they sealed the entire
Also,
place.
the instruction.
no, you see one thing, you cannot have your cake and eat it too. Simple thing is this, your coal has been seized.
My lord.
Now, whether it rightfully belongs to you or whether there's been a violation of some laws, that will be decided in due course. You are scared that in the meantime, your coal will decay
My lord.
and you will not be able to sell it. However, you have asked for a stay of the e-auction notice. That has been stayed. Now, what more do you want?
My lord,
You either, you don't allow them to sell
in that case, my lord.
because we tell them you sell it and deposit the money. If you think that they're selling too low, you go and join the auction process and buy your own coal.
My lord, I have to pay twice for my own stuff.
That will come back to you, na? Or you don't sell it, or you don't buy it, let others buy it. Then if it's going to be an auction, they're going to get a good price for it.
Otherwise, let them come up with the affidavit. In the meantime, I'll ascertain the cost also and keep a proposal before them. If they can prove it to the indemnity bond, I'll submit it before the authority.
I don't know. Right, mister? S.R. Barwa, submit that. What? Who's going to file affidavit?
Respondent 4 and 5.
Submits that he needs how much? How much time?
2 weeks, lord.
He needs 2 weeks time to file affidavit on behalf of respondents number
4 and 5.
4 and 5. This is the matter of the thing. Give it in.
Second or not second?
Yes. Mr. Chetia, affidavit, and what is the thing?
They admitted, among they have completed the work, my lord. 7 of our affidavit maybe. Only because my lord, president of the municipality has not signed my lord, that is why my lord.
Okay, we'll dispose it of.
Yeah.
Heard, mister?
The work, my lord.
B. Borbahan, learned counsel for the petitioner. Also heard Mr. M. Chetia, learned counsel for the respondent. Right. The petitioner's case is that
the petitioner had participated, no, had been issued a formal work order dated 6/7/23, issued by the respondent number 3 for the value of rupees 2,93,650. Pursuant to a tender inviting bid for inverted commas improvement of bylane connecting Bodoti Road, Ward number 3, Bipuria, inverted commas close. The petitioner's counsel submits that the contractual dues of the petitioner amounting to rupees 2,93,650 have not been paid to the petitioner, despite the work having been completed. Next, Mr. M. Chetia, the learned counsel for the all the respondents submits that the petitioner will be paid the admitted bill amount of rupees 2,93,000.
There are 7 days.
Within the next few days, subject to the subject to the approval of the chairperson, Bipuria Municipal Board. I have heard the learned counsel for the parties. Para 7 of the affidavit in a position filed by the respondent number 3 states as follows, page 29. The fact that the petition, that the respondents have admitted, due to the fact that the respondents have admitted that they are liable to pay to the petitioner the amount of rupees 2,93,000, and that the same is to be approved by the chairperson, Bipuria Municipal Board, this court directs the chairman of the Bipuria Municipal Board to take a decision to do the needful in respect of the petitioner's admitted amount within a period of 1 week from the date of receipt of a copy of this order. Thereafter, the amount payable, the dues payable to the petitioner, the admitted dues payable to the petitioner should be paid within a further period of 1 week. For this petition, accordingly disposed.
If the affidavit is waiting, probably by the second hour filing. There's some serious allegation regarding the workers that has been attached.
Okay.
Fraud and all has been.
Mr. B. Gogoi submits that he will be filing affidavit in a position within the course of the day. Accordingly, leave this matter after after 2 weeks. In the meantime, the petitioner may file affidavit in report.
But in this case, my lord, the petitioner has paid before the authority for inclusion is named, my lord, the my lord, a garment manufacturing license, which was held in the name.
When is this government letter dated 5/12/2024? Government letter.
My lord, today they have filed.
Malak, we are going to file. I have already started the copy
Okay.
today. So maybe
What about that other WPC? Is it, what has happened to it? 6552. Huh? That is your case.
That is not my case.
Then why have you mentioned it?
Because blood, the fact of the matter is that one of the brother.
So there is, you see, so there is a brother also involved. And your unit was sealed because of that case. So we take it together.
the custody, safe custody.
Mr. Udas, Miss Udas, learned counsel for the.
Malak respondent number.
But I will
State
satisfy your
respondent.
lordship. I will satisfy your lordship as to how, he has.
Huh?
admitted
3 and 4, Malak.
respondents number 3 and 4 submits that affidavit, will be filed,
My lord, yes, already copies are going to file
will,
today.
will be filed during the course of the day.
My lord.
Ms. A. Nayan, appearing for the respondent number 1.
For two also,
Acha, 2,
3 and 4.
2, 3, and 4. Okay. Are you filing anything?
Only four has
Extra extra copy, my lord.
Are you going to file or not filing? Have you got any role to play?
Yes, my lord. They have the role to play.
Okay.
Okay.
Okay, is granted how much time? Is granted 4 weeks time to file affidavit in opposition. Right, he will serve. And then you write, list this matter along with WPC, tag this matter along with WPC 6552 of 2014.
My lord, now, my lord, the government of India, my lord, would take a call against the application filed by us. They are the authority, not they, my lord. They have sent their proposal.
Let me get to know why you and your brother have filed different applications and over the same unit.
Because, my lord, I am satisfied with the forms of, my lord, hearing as to how he has manipulated and as to how, my lord.
That is why I am tagging them together. The cases.
Okay.
That copy.
Acha, just write one thing, huh? It appears that in WPC 6552 of 2014, the brother of the petitioner herein has filed, has prayed for being given the gun manufacturing license, which the petitioner herein has also claimed. Huh?
Like, here also, my lord, similar thing.
What is this matter? 30?
32, ma'am.
32.
Here,
of blacklisting today.
here, my lord, I have filed, I have prepared, my lord, I have already served the copy. It's ready for filing, my lord. Affidavit on behalf of my lord, respondent numbers 2.
So what do you want?
3. So I may be, it may be taken up some other day so that it will be, my lord, on record.
Yes, madam.
May it please your lordship, lordship, I apologize for appearing in VC. Lordship, there is a little bit of a confusion in this matter as far as the respondent number 1 is concerned, your lordship. Respondent number 1 has been mentioned as Principal Secretary, Election Department. So initially the state government council had accepted notice. But if your lordship sees on the last occasion when this matter was taken up, this court had mentioned this issue that we will decide about it on the next date. So today is the next date, your lordship. So the issue is like, so instead of, it is Principal Secretary, Election Department, and I am here for the Election Commission, basically, lordship. Now, there is a particular notification. My junior associate can hand over that notification, your lordship. So according to that notification, the Principal Secretary, Election Department and the Chief Electoral Officer of Election Commission of India, they are the one and the same person. Basically, the CEO Assam is holding the post of Principal Secretary, Election Department. So, lordship, so there is this confusion on whether it would be the Chief Electoral Officer who would be appearing in this matter, or would it be the Central Government Council who would be appearing in this matter? And if your lordship can see paragraph number 5 in this writ petition. So
You see, when the state of Assam is represented,
yes, your
the
lordship.
state of Assam has to be represented by an officer of the state.
Yes,
not the central government.
of course, your lordship.
If you want the CEO to be a party, that is a separate office altogether. So you'll have to make a application.
No, your lordship. Your lordship, it is just that confusion, since your lordship has mentioned that it is the state government who has to appear. So in that case,
I'm not saying it is the state government who has to appear. I'm just saying.
Yes,
that
your
if
lordship.
the respondent number 1 is the state government, a state government has to be represented by a secretary to the state government, not by a CEO.
Yes.
That's all.
Yes, your lordship. Very well, your lordship. Much obliged. Yeah.
So, you want the time to file? You're filing it today.
I have already served a copy today. I will be
You file it today.
ready.
You want to file any reply? or something?
Because I may have to file.
Okay, right. Ms. Yudas submits that affidavit in a position has been filed today on behalf of
Respondent number 3.
respondent number 3. Mr. List the matter after, how much time do you want?
1 week.
List the matter after a week. In the meantime, the petitioner may file affidavit in reply.
Oblige, your lordship.
Recheck for consideration of interim order.
Huh?
But I'll be recheck for consideration of interim order.
Okay, on the next day, an attempt should be made to consider the interim order. What consider if you're filing a reply, the entire matter will be disposed.
That's all right.
Okay, you write Mr. A. Dasgupta appears for the petitioner in the beginning. The senior counsel appears for the petitioner. Item? What to do? In this contempt case, you write. No one appears for the petition on call. The petitioner has not been represented. On the last 4 consecutive dates also. The matter pertains to non-compliance with the order dated 15/3/2018 passed in WPC 2727 of 2030. During the proceedings of this case, many of the benefits that were to be provided to the petitioner have been provided. And in terms of the order dated 17/2/2025, the counsel for the respondents had submitted that as per his knowledge, the Provident Fund Commissioner had written a letter to the Managing Director, Assam Tourism Development Corporation Limited, asking for the details of the petitioner and his legal aids, so as to disburse the Provident Fund to them. However, as stated earlier, no one has appeared for the petitioner on the last 4 occasions. Today also no one appears for the petitioner. This court had also, this court had also issued notice to the petitioner on his last known address by order dated 17/2/2025. In this respect, the office note dated 3/5/2025 states that neither AD card nor unserved notice has been received that in response to the notice issued to the petitioner. That's fine. In the beginning, right? No one appeared for the petitioner or for the respondent. Or for the respondent. Oh, very good.
One minute.
Yeah, who is one? The Provident Fund Commissioner?
Yes,
Huh? Item
33.
33 is the content. So you are appearing for Rajesh Prasad is tourism, he's got nothing to do. Okay, right, no one appears for the petitioner and that's all. No, just say Mr. B. Gogoi appears for the respondent number 4, 4. What is to be done here?
Lordship, except for on the last occasion, I also have informed Lordship. The Provident Fund Commissioner has written them, asked them to give their details. Otherwise,
Everything is finished.
everything is fine.
But they're not coming also.
Yes, Lordship.
That's right. Don't say, and Mr. B. Chaudhary appears for?
For the respondent 1 and 2, Lordship.
1 and 2. Okay, right. In view of the fact that the petitioner has not appeared for the last 5 days, 5 consecutive court days. This court is not inclined to pursue this matter any longer, inasmuch as the Provident Fund may have been dispersed to the petition. In view of the above, the contempt petition stands closed. However, if the Provident Fund has not been disbursed to the petition, the petitioner would have the liberty of approaching this court again. The contempt petition is accordingly closed. Yes, yeah.
Attempt 5 part, that matter, it was in the morning.
Partner, this,
Before
he
typing,
does
but
is
she
here.
has not appeared. Maybe at
At
2.
2 o'clock.
At 2 minutes. But-
Yes, you tell her at 2. What about this review?
Lordship, review, we had filed
You withdraw? What? Nothing remains. You withdraw?
Yes, sir.
Mr. B. Chaudhary submits that. As nothing remains to be decided.
Some liberty, Lordship.
As on date, he may be allowed to withdraw the review petition. With liberty to approach the same if the petitioner files a contempt petition pursuant to the order dated so and so, that earlier order dated so and so passed in WT. The prayer of the petitions council is allowed. Review petitions council is allowed. The review petition is accordingly closed in terms of the submissions made by the council for the review petition.
Yes. Okay.
But no point now, then nothing remains actually.
Yes, sir.
Except that Provident Fund, whether it's paid or not.
Yes,
That also we don't know.
Lordship, the view was that whatever as on date, when he was walking.
Yes.
Lordship,
So now nothing remains.
others, nothing.
Yes, madam, we are waiting only for you.
This is your lordship.
Yes.
Here, your lordship, file our affidavit, your lordship.
Oh, yeah, fine.
Yes, your lordship.
When?
Yesterday, your lordship, already today, early morning, your lordship.
Yeah, let me see. There's nothing.
Nothing.
Okay, then I'll dispose it off.
Your
Yes, they
lordship,
have admitted everything, that I was appointed 1998, everything.
Yes, madam, whatever you said. No, okay.
your lordship,
me.
that
I'm ready. I don't have. you just tell-
affidavit, your lordship, call for records.
No, I'm ready. I'll accept whatever you say.
Your lordship, I am relying on my paragraph 7 and 8, your lordship.
7 and 8. Okay.
7 and 8. And your lordship, pertaining to that, your lordship, paragraph 5, your lordship. That is on page 47,
Paragraph 7.
paragraph 5, your lordship.
Paragraph 5, yes.
47, I would like to read it, your lordship.
Yes.
That the answering deponent humbly begs to state that in the earlier writ petition 485/2011, the claim of the petitioner was for arrear and current salary. Though the Honorable Single Judge dismissed the writ petition, but the Division Bench of the Honorable Court in Writ Appeal 190 of the 2017 directed to release the arrear and current salary of petitioner, taking into an account of the fact that the petitioner has been rendering his service. Thereafter, Your Lordship, NPS, Your Lordship, paragraph 6, that the answering deponent from the text to state that the service of the petitioner, that is the Pradeep Kumar Sharma, was regularized on 11/7/2007. Therefore, he is entitled for NPS. The petitioner have also accepted the order of regularization. Moreover, the section 31 of Assam Service Pension Rule 1969 stipulates certain condition when a service of an officer qualifies for pension. Since the petitioner has failed to fulfill stipulated condition, that is in Rule 31 of Assam Service Pension Rule 1969, therefore the petitioner is not entitled for pensionary benefit under old pension scheme, Your Lordship.
Why? Because?
Your Lordship, the section emphasizes that section 31 of Assam Service, it is in paragraph 6, Your Lordship, page 47.
What does 31 say?
Your Lordship, Assam Service Pension Rule 1916 stipulates certain condition when a
Only
service of
three
a-
conditions, only three conditions.
when a service of an officer qualifies for pension, since the petitioner has failed to fulfill stipulated condition, that is Rule 31, Assam Service Rule, therefore the petitioner is not entitled. Since
Okay.
Give me the pension rules, 1969. There's only three requirements only. One is the, yes, yes, this is all fulfilled in fact. Division bench has said, firstly, service must be under government, it is under government. Secondly, employment must be substantive and permanent, it is, because it's through a regular selection process. Third is service must be paid by government, paid by government. Then it says, provided the governor may, even
in
though
my
either of
paragraph
the,
7, Your Lordship, I have also stated that the Pradeep Kumar Sharma had been working as assistant teacher against the resultant vacancy of principal as per office order dated so and so. dated-
no, that is wrong. That has been categorically stated otherwise by the division bench. It's not against the post of principal, it's a resultant vacancy. Resultant vacancy. That means the principal post was filled up and the resultant vacancy that occurred.
And Your Lordship, on my last, Your Lordship, last paragraph. Your
The
Lordship, that
retirement,
is-
yes.
That is on paragraph 8, Your Lordship, page 48.
How can this deponent say such a wrong thing in violation of the division bench order on fact?
Your Lordship, here one.
Because this is a
submission there.
resultant vacancy due to the retirement of the principal.
Your Lordship, Pradeep Kumar Sharma, the monthly salary of the petitioner, that is Pradeep Kumar Sharma, was stopped with effects from 1/1/2006 by the Treasury Officer
Correct.
Nalbari due to non-availability of GPF number.
Correct.
And a proposal for opening GPF account number was also submitted to the DSC. Assam wide later so and so dated 8/10/2007. It is to be mentioned here that the arrear salary with effects from 1/1/2006 to 28/2/2019 has already been drawn and disbursed to the teacher by governments dated so and so and the number so and so under new pension.
And he retired?
He expired.
He retired. He expired after retirement.
No, during pendency of the service on 30th of October last.
Acha, then why did he file the writ petition?
No, it was filed earlier, my lord,
For what?
for granting of GPF because he has been.
For grant of
placed
GPF.
under NPS.
GPS.
No, so
number
the
given-
present writ petition has been filed for what?
Present petition is that.
He should be giving
Old pension.
GPF. He should be giving GPF for the old pension.
Yes.
Okay.
That is the claim. Otherwise, I have got a.
So otherwise, he was supposed to retire when?
In 2028.
28.
He has
So he
30th
expired
of October
when?
last.
Expired when?
30th of October 2020.
30.
2024
2024. Okay.
during service.
So retired to retire on in 2028.
2028 as per. That is
Okay,
my limited.
that's all.
That's
So,
sufficient.
So, writ petition is allowed.
Much.
I'll pass the order later.
Deeply.
The amount deducted for NPS.
Huh?
Amount deducted for the.
Okay,
NPS may
to
be
adjust that
converted-
amount, no?
May be converted.
To adjust that NPS in the,
To the GPF.
adjust NPF to GPF. And to, that means they have got to give you a GPF number now.
GPF account is to be opened.
Open
That
and,
proposal was already submitted with the principal.
GPA,
by IS
GSC
also.
has already been submitted, your lord.
Already submitted.
then what remains?
But the account is not
Open.
open.
So GPF proposal already submitted.
Already submitted.
Just a
Principal
minute, just a
secretary
minute.
also says so, and the high executive also says.
Where does it say? Out here, it says that out here.
Your
Okay.
lordship, my parent.
GPF account, the GPF,
On dated 8/10/2007, it was submitted by DSC. Assam
Why
White
did you
Office Letter
submit?
has already,
if he's not entitled to it, why are you submitting?
it is under new, as per my instruction, your lordship. it should
GPF
be
is
under
in the new pension, there is no GPF, madam. Is there any GPF in the new pension? There is no GPF in the new pension. And you have admitted in your affidavit that he is working since 99.
98.
90, no, pay is since from 99.
Did
That
you-
order for regular basic pay is from 99, I think.
Order is 99, but he is getting. from
With
since the
effect,
date of
yes,
decision.
appointment in 98. I
Yes.
98.
So that why it's a.
Anyway, good. So, thank you.
Much.
You put this also. So I will pass the order, it'll take maybe 1-2 days.
Much.
Allowed.
I'm deeply aware.
The lordship, the senior is like anything matter, so kindly passing over the time if it's possible. Like.
How long?
Like, it will take around another, this one, 30 minutes.
Who's the senior?
Engage count.
Huh?
Let it come on Monday.
Does the inquiry report support your case?
No.
I don't think it supports the case. Huh? Against you? So I think that nothing remains in this petition. You've got to go to the civil court, I think. Hai na? There's nothing here.
Next day.
No, there's nothing next date. Where is that? Where is that? Where is the order?
Order is not.
Okay, where is yes.
Lordship, next week will like suffice the.
No. If it hasn't come, I'm sorry. This is a disputed question of fact. If you're disputing this speaking order, nothing remains. Can this court decide a disputed question of fact?
Lordship, like.
Yes.
The council will appear next day.
Oh, no. Let the council appear before the division bench.
Section 16 of the.
Huh?
Section 16 of the Telegraph Act. Pay the price. They can go to district judge.
Section 16 of the. Where is the, which court is she in?
She's in,
Yes, madam.
Big industry member. He was just constructing big industry. And
Now, madam, the thing is that if you come to the speaking order, page 42.
I know.
This is done as per the order of this court.
What was done, madam, and it was found that big industry was there. Your lordship, may kindly see the.
Madam, this is now, you see, I cannot take evidence. Please go to the civil court with regard to this
My
question of fact.
records are here, my have changed the record.
What record? You are the petitioner.
Inquiry, as per the inquiry.
So if there are two inquiry reports, if they are at variance with each other, which
Two inquiry reports I have annexed, but they tally with each other. madam.
they tally with each other. And this,
Subsequently, my.
now let us see that, let us see the
Yes,
two
yes.
inquiry reports.
Inquiry reports, one is at page 27, madam. One is 28.
Yes,
With reference to subject.
then,
So I have to inform you that Abul Hussain Losper proprietor, Losper Brick Industry, a Borala company has filed a clear petition before the undersigned for compensation against the damage which occurred during screening between the lower tower location so and so. The matter was inquired through LR staff who reported that the brick industry was located at that place and suffered damage.
then,
In this connection, I am forwarding clearly the prayer petition.
okay,
which-
then,
So,
then,
subsequently, there was another inquiry and that is at page 36. As per your order dated 25/8/2014, I have conducted spot verification of the land.
this page 36 is a,
This is Connection L, man.
it is a part of annexure L.
Yes,
This is written by whom?
it is the circle officer. ma'am.
Circle officer.
Yes, my lord, the handwritten,
Handwritten order.
my lord, I have typed, my lord.
You have typed,
Your
and the
lordship,
original is
signature,
handwritten.
The seal is there, my lord, at page 37.
Don't shout, madam. Don't shout.
Page 36.
Might not be to your benefit.
See, a seal is there, seal along with his signature, my lord. This is the report of the circle officer,
What is this date? 29/8/14.
2014, my lord. It is 28/8/2014. The
It is
Bengali-
29/8/14 according to you. Your translation.
Bengali version. As per your order dated, so I have conducted spot verification of the land and upon which the lawsuit brick clean of existed under Moja so and so at Hailakandi. Upon verification, it is found that a big clean is existed upon the land under that number 38 period patta number 2 measuring so and so. The owner of the brick clean is Abu Hussain Laskar of so and so. During inquiry, it has been learned from the owner of the state brick clean that the remaining land has been used by him for cultivation. The appropriate report has been placed before your honor for information and necessary action. So subsequently, my lord, a list was prepared, my lord, for the my lord, beneficiaries, but in the list of beneficiaries, name is not included. So he approved this honorable court by filing a writ petition. And there was a direction, the writ petition was disposed of with the direction to take a hearing and verify the records and thereafter pass the necessary order.
Cause an inquiry, shall cause an inquiry, madam. It says here. Shall cause an inquiry.
But subsequently, another inquiry was held after my lord 5 years, my lord. During the lapse of time, there was.
This is, madam, this is on the basis,
Means of,
this is on the basis of an order passed by this court. This order is, this inquiry, speaking order has been made on the basis of a order passed by this court.
so another inquiry was held and they did not find anything there. Naturally, because there was flood and, my lord, due to lapse of time, my lord, it was washed away by flood and.
And And was this 11/6/2014 and 29/8/2014 a part of the record in WPC
Yes, ma'am.
3-2? So knowing that these two inquiries had been made, this court had anyway directed a fresh inquiry to be made. So what
And
remains?
the hearing also, but he produced all this, and there is, your lordship may kindly see at para 3 of the speaking order.
Yes.
Also appears that the petitioner could not show any document, NOC from the district administration, consent from the pollution, and so. But whereas the petitioner has annexed all the documents in this writ petition also, he has fulfilled all the required minor, criteria, minor,
Okay.
except B, C, and D, minor.
That's all?
And he placed before the authority also at the time of hearing, but these were not considered.
Yes, Mr. Zaman, which 16/4? 3. This is with regard to sufficiency of the compensation. This is a different thing. Any dispute arises concerning the sufficiency of the compensation. Yes, the elections. This is not, 16/3 will not be applicable.
And my lord, page 27 is the notice. They themselves have admitted the petition is entitled for compensation. They calculated on.
Yeah. Madam, just one thing. When in the earlier writ petition,
Here also.
in the earlier writ petition, these two documents were shown to the court. Were it a part of the writ petition? If it was a part of the writ petition, despite you putting those two documents in the earlier writ petition, this court had directed in 2017 to have a fresh inquiry made.
But that-
How can I now rely upon that earlier document?
She may kindly see at page 27.
No, I'm not going into, I cannot go backwards. You see, when you cannot go back to an issue that has already been taken note of
But
by
we
in
cannot
another
take
writ
these
petition.
documents. These documents belong to the office, my lord. Of the department power grid.
You just get me this WPC, the record, huh? WPC 3211 of 2014. Once I find that,
They also calculated. my lord.
3211 of 2014. Okay, right. Heard Miss
SB two.
S.B. Chaudhary, learned counsel for the petitioner. Also heard Mr. Who appears? J. Handik for 1, 2, 3, and 5. Mr. Zakir Ahmad, Agud Zaman, learned senior counsel. Mr. M.Z. Ahmed, sir, learned senior counsel, appears for respondent number 4, assisted by Mr. A.M. Doctor. The petitioner. This case is that he had established a brick kiln industry. In the Hailakandi, brick kiln industry over his parental land. And for that purpose, he had executed lease agreement dated 10/5/2008 with Ali Ahmed Laskar, which provided for a lease up to December 2028. Upon establishing his brick factory, the petitioner was operating the same. The respondent Power Grid Corporation of India Limited undertook the work of construction of a 400 kV D/C, Silchar Purba Kanchan Bari line. And for that purpose, it had started erecting towers above the petitioner's brick industry. It is the case of the petitioner that tower location of 22/0 and 23/0 is over the land of the petitioner, where the brick kiln industry is located. The petitioner has thus paid for compensation for the overhead lines that has been constructed over his land. First off, the petitioner's counsel has taken this court through the letter dated 11/6/2014 issued by the Circle Officer Hailakandi, which is to the effect that the LR staff, what is LR? Which is to the effect that land and revenue staff had inquired into the issue raised by the petitioner, who reported that the brick industry was located at the place, at the concerned place and suffered damage. Full stop. She also relies upon the letter, the handwritten letter in vernacular dated 29/8/2014, allegedly issued by the Circle Officer, which is to the effect that during inquiry, it was learned from the owner of the brick kiln that the remaining, from the brick kiln that, no, it was, upon verification, it was found that what does it say? Okay. It was found that a brick kiln was in existence upon land under dark number 38 periodic number 2, measuring 7 kathas and 8 chatak. Huh? It says 8 chatak. Yeah, overwriting is here. This is your translation, madam.
Yes, madam.
There. 2 chatak. Right, 2 chatak. Right, 8 chatak. Because it's as per this. I'm not reading. Full stop. Next para. The petitioner's counsel submits that subsequent to these events, the petitioner had filed WPC 3211 of 2014. With regard to the construction of the overhead line over the land of the petitioner. However, WPC 3211/2014 was disposed of by a coordinate bench of this court by directing the Deputy Commissioner Hailakandi to cause an inquiry as to whether the overhead line had passed through the land of the petitioner containing the brick industry, which is stated to be located in the land covered by dark number 39, 90, 225, 227 of Pata number 2, village Barkai La Kandi, at page 40. The petitioner's counsel submits that subsequent to the order dated 5/9/2017, passed in WPC 3211 of 2014, the Deputy Commissioner Hailakandi issued the impugned speaking order dated 14/2/2018. Holding that no brick kiln was found to be set up in the vicinity or within the range of the line corridor during the execution of foundation and erection of the electricity tower. As such, no compensation could be given to the writ petitioner for damage of a half-done chimney, which was constructed in an unlawful manner after finalization of root alignment and spot installation of the foundation work. Of the transmission line. Full stop. Page 43, that is next. The petitioner's counsel submits that the impugned speaking order not being in consonance with the earlier order dated 11/6/2014, and letter dated 29/8/2014 issued by the Circle Officer Hailakandi. The speaking order should be set aside and compensation should be paid to the petition. Full stop. Next paragraph. The counsels for the respondents, on the other hand, submit that despite the orders dated 11/6/2014 and 29/8/2014 allegedly issued by the Circle Officer Hailakandi, the coordinate bench of this court had wide order dated 5/9/2017 passed in WPC 3211 of 2014, directed that a fresh inquiry should be held with regard to the claim of the petition. As the inquiry report had indicated that had not supported the case of the petitioner in terms of the speaking order dated 14/2/2018, the writ petition should be dismissed. In the alternative, they submit that if the petitioner challenges the correctness of the speaking order dated 14/2/2018, she should approach the civil court as disputed questions of facts are involved.
My lord, in this case, they have filed affidavit, they have, my lord, admitted. Now they are, my lord,
They have admitted what?
admitted, my lord, that they have offered compensation and the petitioner refused to accept. That means the, my lord, the electric line was there. Your lordship may kindly see the affidavit in opposition filed by Deputy General Manager Power Grid Corporation. Your lordship may kindly see para 12 of that affidavit, my lord. That they are saying that they calculated according to the rates fixed by the concerned department, which has been further duly verified by the concerned district revenue office, but the petitioner has refused to receive the amount till date. That means they are admitting that there was a break clean and he
Petitioner is not at all entitled for any further compensation. He has been given some compensation.
maybe further, my lord.
For what?
Service damage.
Huh?
For service.
For service damage.
They have not taken it.
Huh?
Saying that they have not taken that money. It's lying with the.
Okay, just one thing, right? The petitioner's counsel submit, the counsel for the respondent number 4 submits that compensation had been assessed for the petitioner with regard to the surface damage, with regard to the damage caused, with regard to the surface damage due to the erection of the transmission line, which the petitioner has however refused to accept. He submits that if the compensation that has been assessed for surface damage can always be furnished to the petitioner as and when the petitioner approaches the deputy commissioner Hailakandi. Next one. So what have I said? I have heard the noise part for the people. The extract of the order dated 5/9/2017 passed in WPC 3211 of 2014 is reproduced herein below as follows. Para 5, page 40. Okay. 40 onwards, still the end. Next para. The extract of no, this is the speaking, the impugn speaking order dated 14/2/2018 is reproduced herein below as follows. Page 42 and 40 till 43. Okay. Next. A perusal of the above would show that the claim of the petitioner has not been, the claim of the petitioner has not been accepted, has not been found to be correct in terms of the inquiry held pursuant to the order passed by this in WPC 3211 of 2014. As such, when the petitioner has put a challenge to the speaking order, to the contents of the speaking order, the same amounts to disputing the questions of fact that have been found in the speaking order, that have been recorded in the impugned speaking order. This court is of the view that as the issue raised by the petitioner is not supported by the impugned speaking order, the petitioner would have to approach the civil court for redressal of his grievance, in as much as evidence would have to be recorded with regard to disputed questions of fact. In view of the reasons stated above, this court does not is not inclined to exercise its discretion in the present case due to disputed questions of fact being involved. The petitioner is accordingly given the liberty to approach a civil court or any other appropriate proceeding forum where proceedings can be, where evidence can be recorded for redressal of his grievances. The above being said, the compensation assessed for surface compensation, surface damage, should be released to the petitioner if the petitioner approaches the authorities for release of this. The writ petition accordingly dismissed. Next.
But on last occasion, I informed that they have already moved for the ceiling proposal. But the present instruction is that ultimately some objection is there. They have reverted the file, and after making the clarification, yesterday only they have sent it to the government.
Yeah,
The chief engineer PWD has sent the file again to the government
for what?
for the first proposal, first demand proposal. It
State
was-
department proposal, what do you mean? So where is the letter? Let us see the letter.
Yes, but follow the yesterday's letter I don't have, but the earlier ceiling proposal submitted.
No, earlier ceiling proposal is not being accepted, no.
It
That's
was,
what-
it was, yes,
It was under objection, so what's the point?
yes, yes.
Where is the yesterday's letter?
Yesterday's letter, this is a telephone case. Yesterday's letter, I don't.
I want that. Where is the yesterday's letter?
I'll place it, but telephonically I have received. This is the earlier ceiling proposal. Because of some difficulty, it has been sent back. And now they have rectified and sent it yesterday. I'm told yesterday they have sent. That yesterday's thing I don't have. I'll. place it.
Where is this is of 24.
Yeah, then the second page, Lord, it was in the month of February 20, single page. Lord. The single page kindly see. The ceiling, checklist for ceiling proposal, it was submitted on 25th of February 2025. Then it was processed, but the finance department has sought some clarification because of that, but it has been sent back. Now they have again rectified and signed it. I am told that yesterday they have sent it to the government. The CPG has sent it to the government department. That all the place, I have not received yesterday's communication.
We'll list it next week. You bring the letter.
I'll get the communication, please.
Mr. Dina submits that the ceiling proposal for payment of the petition's contractual dues had been sent to the finance department,
It was by the Sandeep Siam, he is the chief engineer. He has sent it to the department.
to the finance department on 26/2/2025. However, the same was returned due to some objection. He submits that a fresh proposal had been sent yesterday, that is yesterday, for sanction of the fresh ceiling proposal.
Chief engineer has sent it to the department. The chief engineer has to send it to the department. The department will
He
send
submits that the fresh proposal has been sent by the chief engineer, by the concerned chief engineer. PWD, to the secretariat, PWD secretary.
Yes. Yes, sir.
Was that Mr. Bidinath shall produce the letter that was issued by the chief engineer PWD bracket border roads and NEC works. That was issued yesterday, huh? To the PWD secretary on the next week. This is the matter of when?
Next week.
Give a date. Anything to say? Miss K. Fugan appears for point number 3.
Jirat compensation.
Huh?
Jirat compensation, not compensation.
Not Zerat. Okay, Zerat compensation. Zerat. Huh?
The order of
If they want, they can take it.
order dated 21/2025. Lordship has directed him to see whether my grievance has been addressed in the committee. There was a committee formed during the pendency of this petition.
The petitioner matter has been placed before the committee lordship. The committee is not sitting lordship. When we to sit lordship, we take a decision.
When is it sitting? 6 months have, nearly 4 months have passed.
It's short to that.
Who is the concerned secretary?
The director, but when we talk about the company is director.
Let us see the order.
Lordship.
Order is at page 24. Page 23 it starts. Page 22 it starts. The operative part is at page 24. Paragraph 5 and 6 I think.
Page 24, yes.
If I may read. Well, paragraph 5. Taking into account the above statement, this court therefore is of the opinion that the interest of justice is met if the petitioner is permitted to submit his uncleared bills in the proper format and a direction is given to the concerned responding authorities to make payment to the petitioner the amount which he is entitled to after necessary verification. His next para. Accordingly, this court therefore disposes of the instant which petition thereby giving the liberty to the petitioner to submit his unpaid bills in the proper format, and thereupon the respondent 5 and 6 shall make necessary verification as regards the petitioner's entitlement. And upon verification, it is found that a petitioner is entitled to the amount so claimed or such other amount.
Okay, look, this committee has been formed in July 27. You have not sat here till date.
That's otherwise.
Why have you made the director only a respondent?
The director is the one who has to release the payment. Earlier also some payments were released that was given by the director.
Maybe, but then the money has to be given from, taken from the government.
Earlier which payment was given by the director. The directions were given only to the.
You tell the director to appear next day. What is this? What is this? Tell him to appear tomorrow.
No, 10 days can not.
For what? You're not complying. You're never going to comply.
The director, he placed them for the government lordship.
Where is the letter written by him to the government?
One letter written to me lordship, where he mentioned lordship. The matter has already been placed before a committee and the meeting of the committee will be held within the short period. After that, the concerned office will move the finance department for budget provision for payment of the same in the next financial year.
This is the next financial year.
Yes.
When is this letter written?
It is 27/3.
27/3. Now this is the next new financial year.
Lordship.
What is it?
Give it 10 days then.
Yes, right. Where is that court order? Page?
Page 22. It starts from 22.
Right. The para 5 and 6. Para 5, 6 and 7. Of the order dated 24/7/23 passed in WPC 649022 states as follows. Page 24. The above order not being complied with, the petitioner has filed this contempt case on
17/8/2024.
17/8/2024. Next part. In the order dated 20/01/2025, passed by this court, it has been observed that the Secretary to the Government of Assam, IPR, Printing and Stationery Department has constituted a committee on 30/07/2024 pursuant to a decision of the Cabinet for addressing issues regarding pending court cases relating to payments to SMEs. Next paragraph. Mr. B. Goswami, learned counsel for the respondent number 1. Huh? Huh? N Goswami. Out is B. Goswami. Okay, just say, no, just say, the counsel, don't say the name, just say the learned counsel for the respondent number 1 had been directed to obtain instructions as to whether the committee constituted on 30/7/2024 had considered the case of the petitioner. Next paragraph. Mr. N. Goswami, learned counsel for the respondent number 1, submits that the committee has not considered the case of the petitioner till date, as the committee has not sat. Next.
Verification was done for the petitioner's bill.
Huh?
Verification was done for the petitioner's bill. Please come on 7,46,257.
Mr. N. Goswami has also submitted a letter dated 15/9. No, 27/3/25. Issued by the Director, Printing and Stationery, Assam, which is to the effect that correspondence is being made with the government regarding release of payment against pending bills amounting to rupees 7,46,257.50 in connection with WPC number 6490/2022. And the present contempt case. Towards preparation of F1 cards, bracket lamination, binding, purchase of paper, etc., bracket close, during the year 2013-14. Mr. N. Goswami shall produce the up-to-date status report with regard to the present case, failing which the concerned director will have to, failing which the respondent number 1, failing which who are the respondents? Failing which the respondent number 1 would have to explain personally as to why the order has not been complied with. This is the matter on when? Second.
Please, Your Lordship, your reference to P9 to be appearing this matter is on Lexington Code 5, passable matter for a timing on.
It's payment of thing, no?
He has the instruction, Lordship.
The instruction was.
Wait, please, Your Lordship. During the pendency of the contempt petition, my lord, petitioner expired on 22/2022. Now, my lord, petitioner wife, my lord. Substituted, my lord.
Miss
R.S. Devi.
R.S. Deori, learned counsel for the applicant, prays that the wife of the petitioner should be impeded so as to substitute her deceased husband who is the petitioner in the contempt case. The prayer of the counsel for the applicant is allowed. Accordingly, Srimati Anjali Basumatari, age 50 years, wife of late Jagan Basumatari, resident of so and so, page three, is impleaded and allowed to substitute the deceased petition. The petitioner shall submit the corrected cost title to the registry within 2 days, 3 days, in 3 days. List I is accordingly allowed and disposed of. Then you write in the main case, in view of the order dated 21. What is it today? 21/5/2025, passed in IAC 1409 of 2025. So and so is impleaded as respondent, is impleaded and allowed to substitute the deceased petitioner, who is her husband, who is her late husband. Then who is for the other side? Huh? Where is the impugn or the order?
Order, my lord, 5/10/2018, my lord, contempt petition.
This is for what?
For
MR bill,
paying the outstanding bill amount, my lord.
contractual bill.
Yes, ma'am.
Okay, right. The present matter relates to the respondents not verifying the contractual amount payable to the petitioner in terms of the order dated 5/10/2018, passed in WPC 7780 of 2015. No one appears for the respondents. What to do? Though,
I will verify whether the presently the.
okay, next you write, the petitioner shall verify as to whether the present respondents are still holding the post. That is reflected in the cost item. This is the matter after 2 weeks.
Okay.
Huh? No one appears for the respondents, that's all. What to do, Mr. Hawk? Yes, he's here. Okay, then you have to file reply. Huh?
Affidavit I filed yesterday.
You have to file reply? No need. You want to file reply or not? That's what I'm saying. Mr. S. Hawk submits that. The affidavit in a position has been received by him today. And yesterday, and he would like to file a reply. Within how many days? 2 years, 10 years, how much? Within a week. List the matter after a week. Give a date. The first week of October, or June. 3rd June.
That's the same issue, let it be on 3rd of June, in the meantime, we'll complete the procedure. I got the instruction.
Okay, here also same thing. You have given.
Same issue, same.
Okay, same order.
No, affidavit I will file, madam, in the second page.
Okay, in the second, this
By Friday, I will
item,
Item
40.
40.
Item 40, you write.
By Friday, I will file.
Mr. B. Gogoi submit that he will file affidavit in a position within 2
By
days.
23rd, I will file.
Within 2 days. At least the matter on 3rd. By which date Mr. S. Hawk may file his affidavit in reply. The matter, full stop, the matter pertains to the petitioner being L1.
Yes.
And the work order being issued to the respondent number 5. Yes, what to do?
But instruction has come, madam, there is a specific query. Direction for the.
So there's no post of research assistant in Dayal. Is the post of statistical assistant between SCRT and Dayal, is it transferable? Can a person who has been appointed as a statistical assistant in SCRT, can he be transferred as statistical assistant in Dayal?
My specific
Huh?
instruction, my specific instruction to the extent is that it cannot be, because both are, although these posts are not anchored, they are governed by separate sets of rules. So since I have placed the rules, my lord, all the rules were framed in exercise of provided.
So they have got separate rules.
Separate rules.
Uh,
DIET has separate rules, SCRT has separate rules, framed in exercise of power under provided to Article 309.
So, no, so the post of statistical assistant in Dayal is governed by separate rules.
Separate rules.
And the post of statistical assistant in SCRT is governed by
Not
separate rules.
statistical assistant, my lord, the statistical assistant is not anchored, but other services, those which are anchored, services, they are governed by separate rules. One statistical
So
assistant
statistical assistant post doesn't have any rules
doesn't have.
in either SCRT or Dayal.
Yes, yes. And the prevailing practice which has been adopted since creation of the post is that it is being promoted. And that specific query of your lordship, to the extent who was holding the post on 25th of February 2016, that instruction has come today that the petitioner was there.
So he was considered that time. So why
Yes.
shouldn't he be?
To be considered by the petitioner, that any edicts DPC to have the seat. That is very simple.
But then what about the seniority? He's way down.
The seniority that common gradation is prepared, he is in 16. Now everybody will come in, and he has not made any party to all these persons. Yes, because he is challenging the gradation list, common gradation list, and this at the same time he is not a party of any of the person in the 15 persons.
That is there also.
That is there. That is
Why I have specifically stated, my lord, they are, they have admitted that it is the practice that whenever lordship has recorded in your lordship's last order.
instruction is also there.
The paragraph 13 of lordship's order, my lord.
Whatever.
In the affidavit, they have stated.
Just read it.
Yes. That as regard the, I am reading from the affidavit, madam. As regard the statement made in paragraph 18 of the writ petition, the answering deponent will state that Subhadukti Das and Vipul Kaputi's seniority is taken from the date of joining in SCRT. So whenever I have a very specific statement, whenever a person from.
No, but whatever it is, you see, the fact of the matter is now, the problem is, since seniority list has already been made,
Yes.
whether it is right or wrong, will have to be decided because we have asked for setting aside.
Yes, only to that immediate, the extent of the petitioner only.
Extent of the petitioner naturally, but to the, because even now they are claiming a right to that.
Because even if, my lord.
You have to make them a party, I think.
The lordship looks at the prayer made. Because even if my prayer is that my name should be excluded. Whoever is there. Is to be there.
How can your name only be excluded? There are two other SC,
Because, my lord,
statistical
there are-
assistant.
Because those persons came from DIET. I have placed those records.
They came from Diet, but now they are in SCRT.
Now they are SCRT, but in respect of other cadres, whenever a person joins from DIET to SCRT, their seniority is counted from the date of joining in SCRT.
No, you see, one thing is, you see, if I set aside or I take you out and say that you have to be considered separately without considering them, then they are going to come in appeal. They're going to go in appeal
But-
and say that we were not heard on this aspect.
Not even made party. That's the issue, my lord.
And to that extent, since 3 posts are vacant, there are 3 statistical
It's
assistants.
not so easy, Mr. Council. It's not so easy. I can pass that order, but then that is going to be open to challenge very easily.
But the thing is that otherwise the respondent number 4 was given promotion, and my prayer is only to that extent of SCR, the research assistant in Jorhat campus. Even if the petitioner, respondent number 4 stays as,
You're not trying to understand. Anyway.
even if the respondent number 4 is there in any other vacant position, but otherwise nobody has preferred any challenge ballot. Neither those assuming for a moment, those Tirtha and Ulideka were aggrieved. They ought to have come before this court to challenge the promotion of respondent number 4. They have not come, my lord.
It is only the petitioner. It is before your lord.
Is this a part-heard matter or what?
Yes. What's your part?
I think you should make them parties, otherwise I'm having difficulty in disposing.
Because any other lordship's order, that will have an impact on the other person, 15%.
It will have,
They will come with. Yeah, lordship, I'll file on. Applicant provision.
yeah. I will release this matter,
Lordship.
right? On the prayer of the parties, list the matter after a week.
Okay, after 2 weeks.
After 2 weeks. Uh,
Exchange.
So as to enable the petitioner to file an impediment application. Accordingly, the matter stands released from party. This is a matter.
I'm applied.
Just time 41, my lord. Since you are issuing 3 more, my lord, I am not getting this ready for the 44, which I am only till now, my lord.
You will get in time.
I am getting this salary for the post of the NDA, my lord.
You let him file, let us.
Lordship.
Oh, let's go. Lordship, this petitioner is arising from the award passed to the Climate Award.
Mr. Council, this is a transfer matter of 2000, which year? 2016. You're challenging that. What remains?
Everything remains lordship because I have not been allowed to join the party and I did not go to Principal. Basically, since that no.
Who is for the other side?
The private respondent did not appear. The main party, they did not appear. I have signed the notice for any of the scheme. They received it and I have filed the affidavit also.
Okay, no, so who was the person who was transferred?
I am the person, I was transferred from Guwahati to Tinsukia.
Ah,
But basically, the main issue, lordship may decide the case on merit. If the decided on merit, then if the order go, then I may be allowed to rejoin in the Guwahati also. There is a submitting. But I was appointed as a sub-editor in the management house, which is a newspaper industry, reputed Bengali daily, simultaneously published from the Guwahati, Silchar, and Calcutta also. And as a sub-editor, my duty was to edit the news item, elaborate and short it. And my duty was to sit in the news desk and to work inside the house. And they have transferred my position to Tinsukia as a field reporter. So basically, I raised the industrial dispute on the ground that such transfer order is illegal because it changed the nature of job and it degrade my position also. Because degrade. The sub-editor is a higher position.
okay.
The reporter
So
is
you-
lower. On that ground, I have raised the industrial.
the
dispute.
pay scale is the same?
No, the pay scale basically it is decided by the management. They are not following the.
No,
they are
that
not-
is not the issue. The
Yeah,
issue
this
was.
is not the issue.
Oh.
The issue is that basically it changed the nature of job and which is not permissible as per the law, as per the act. So on the ground, I raised the industrial dispute and the learned labor court decided the issue in favor of the management, holding view that such transfer, while a sub-editor is being transferred to the position of field reporter, it does not affect the nature of the job. So she would find the award is on page number.
So there is no stay order
Stay order is not there.
and you have not joined.
I have not joined. I have not formally terminated also. So I am entitled to this, if the transfer order was to set aside, then I am entitled to rejoin also at Guwahati. But this is
So you have not, so why have you not joined?
because the did not allow me to join.
Yeah, he has to
No,
join,
no,
you have to
this
join
is
at
the-
Tinsukia when there is no stay order.
Uh,
You have got to abide by the order of
No,
the
also-
tribunal.
If the order is illegal,
No, sorry.
Lordship may decide the merit.
Yes, I'm deciding. What is the case?
Lord,
No case.
Lordship may go to the page number 32.
Because Lordship is page 33 says that when proceeding is pending, the nature and condition of the job shall remain unchanged.
No, no, no. Where does it say?
It is the mandate of the Act, Lordship,
Where? Show me.
section 33.
Give me some. That's right.
Section 33, page number 95.
Yes,
May I be allowed to read the relevant portion?
yes.
Condition of services, etc. to remain unchanged under certain circumstances during pendency of proceedings. During the pendency of any conciliation proceedings before a conciliation officer or a board, or any proceedings before an arbitrate or a labor court or a tribunal or national tribunal in respect of an industrial dispute, no employer shall.
That is before a proceeding, before a labor court or tribunal or national tribunal. That's finished.
Yes,
And-
but issue is that before coming here, I was in the labor court. At that time also, they did not allow me to join. Lordship,
They did not allow you to join where? They did not allow you to join where? In Guwahati or in Tezpur?
There,
In Tinsukia.
in Tinsukia, I did not join as a
Ah.
reporter. Because
Mr. Counsel, the question is very simple. Don't have to, go around. This is not a maze. It's a simple question. Did you try to join in Tinsukia?
no, I am not at all interested because such joining.
Okay. Then this
is their position.
33 doesn't cover you, sorry.
Lordship, Lordship have enough time because it is just three. Give me some
I have
time.
got- I have got a tribunal.
Because the finding of the labor court that I have challenged, Lordship, the new point Lordship has raised now that I did not join. The labor court raised the issue.
It is not a new point. It is a point known to you also.
No.
It is a point that you know because you are here saying that you are not joined. It is
But
not.
Labor court, Lordship, the labor court decided on that issue that it is not an industrial dispute. Transfer is not an industrial dispute. And if it is decided.
Yeah,
in
you have got no
2008,
case.
Then this decision might be in my favor. Then the picture of the case might be otherwise,
No. Show me where, why? Why should it be otherwise?
because, yes, page number 32 of my case,
Yes,
page 32,
yes,
the finding of the labor court.
yes, yes.
Possible, I'm going to the relevant portion. It's page 33. Possible. It relates to whether the transfer of a workman named Asiful Sadat Osmani, sub-editor from Guwahati to Tinsukia as field correspondence as an industrial dispute or not. First issue. The admitted fact as per the pleadings and arguments and that before that these are the issues framed by the competent authority that is the Labor Welfare Department. Then these issues are decided by the labor court. So we are confined within the issue. And my respectful submission is that neither the labor court nor the me as a litigant, we can go beyond the issues. So the first issue was whether the transfer is the industrial dispute or not, and why if not.
Show me if it is an industrial dispute. Show me that it is an industrial dispute.
Yes. Second schedule. Page 115, lots of industrial dispute.
Yes,
115.
yes. Yes,
Yes. The second schedule, it is about the matter within the jurisdiction of the labor.
where?
Page number 115.
I have got 115, yes. Matters within 116, matters within jurisdiction of labor courts, yes.
The propriety or legality of an order passed by an employer under the standing orders. Any order
Yes.
passed
Yes,
in exercise or with exercise of the, in exercise of the standing order, it comes into the jurisdiction of the labor court. The application and interpretation of the standing order.
Yes.
Discharge or dismissal of workmen, including waste treatment or of for a grant relief to the workmen wrongfully dismissed. It is not applicable in my case. Withdrawal of any customary concession or privilege, it will cover. All matters other than those specified in the third sheet. So first is that the order, the order passed in accordance with the standing order, which is followed by the management company.
Show me, what is the standing order?
This is the fact, so I'm coming. There is an act, Employment Standing Order Act 1946. This section 3 of the act clearly mandates that every management where more than 10 or 20.
Show me that act.
It's a draft copy. That this standing order defines the condition of service.
Maybe. Yes, let's see.
As per this act, every management company or industrial establishment should have the standing order.
So supposing it doesn't have standing order, then what happens?
Then this order shall become illegal.
Why?
Because the
Show me the relevant portion. Don't just say that, you know, in this act, show me which portion, clause 1, section 2, section 3, section 20, which one, which provision?
I have just one copy of the I'll show.
Okay. We'll put this as part of, I think. It's easy. There's nothing much to discuss on it. Right. Heard, Mr.
F.Z. Majumdar.
F.Z. Majumdar, learned counsel for the petitioner. Also heard Ms. Yudas, learned counsel for 1, 2, and 3. So stop. It has been submitted by the petitioner's counsel that despite the reference case number 10 of 2017 having been dismissed, reference case number 10 of 2017 filed by the petitioner, filed by the management. Filed by the petitioner. Filed by the, where is that? Where is the award?
Award is on the page number 30.
Page number?
32 of my petition.
32, it says management versus filed. Filed by the, referred by the management.
Correct. What is issue is that when the first by rate industrial dispute, then it was referred by the Labor Welfare Department of the government.
Referred by the management. Referred by the management.
Not management also. It is referred by the government of Assam.
Okay, no, referred by the government. Just say. No, despite the reference case number 10 of 2017, which had upheld the transfer of the writ petitioner, white award dated, where's the award? No, that is only an order.
It is award dated 22/02/2019.
No, that is different.
Page number 32. The award. Date of argument 8/2/19. Date of award.
Okay, 22/2019. Whatever I said. Having been decided to the effect that the dispute did not fall under the Industrial Disputes Act 1947, the petitioner has not joined his place of transfer at Tinsukia since even after the award dated 22/2/2009. There is no case, Mr. Constable, no case. Right. Heard this right? Heard Mr. F. Z. Mazumdar, learned counsel for the petitioner, also heard Ms. Hugh Das, learned counsel for the state respondent. So for this, respondent number 2. 1, 2, and 3. What about no one appears for the, anyone is there? No one appears for the respondent number 4. Hearing concluded, judgment is reserved. Nothing is this. Or what, you want to make some more submission?
If Lordship permits the 9.
What submission? You don't come under schedule 2 at all.
Sorry. Hello,
Schedule 2, okay, schedule 2, this is right. List the matter. After 2 weeks, as part heard. As part heard, huh? Huh? As part heard, no. Huh. It will come as soon as after 2 weeks. Yes, Mr. P. Naik.
In this method, the direction was issued to complete the examination as regard his entitlement also within a period of 4 months also. But it, to be honest, also we are still unable to complete the examination. And recently the authority has taken a decision to appoint one auditor. So far as this claim is concerned, because when this claim is.
Look, you appoint or you don't appoint, take a decision, but you've got to comply with the order.
Yes.
That is the only. You're not complying with the order.
Lordship, I have received some instruction and they are telling us to file one IA for extension of time, Lordship. That is under preparation, Lordship. Lordship, granted 3 days for this time to Lordship. In the meantime, I'll find one IA for extension. But the amount is huge, Lordship. And in this regard, Lordship, one PIL was also pending. Very recently, that was dismissed, Lordship. Same issue, Lordship.
Maybe, but then August, this order passed in August, and now you are deciding to think of an auditor. You have been directed to complete the entire thing within 4 months.
4 months now.
Then 4 months ended in December.
Some other payments are already been made.
But this is a different program. This is supply of mosquito nets. And
look, you are saying that they are thinking of a decision to appoint an auditor.
no, that decision has already been taken. The Executive Council has already decided. But appointment has not yet been made.
Okay, right. Mr. P. Nayak, then counsel for the petition. Pray for some time to obtain, pray for some time to obtain instruction. This is the matter. When? Next week? In the meantime, you file. This is the matter on first week. No, 4 June is good enough.